Another, I beg to mention in item number 2, madam. I'm appearing on behalf of the respondent PNR's department.
Yes.
In this case, madam, Mr. Senior Standing Counsel, Mr. Kumar was supposed to appear. But unfortunately, his son has actually taken something inside his mouth, for which actually he has actually taken to the hospital.
Just wait for it. It's an orders case. We will not pass any adverse order. Let it be called out. Don't worry, we will not pass any adverse order. Just wait. Let the matter be called out. We'll take care of the things. Yes.
May I please, I beg to mention item 26, proceed. I taken consent from the.
Just hold on. We are calling out the matters page wise. Yes.
18 to 30.
Now you can mention.
18 to 30.
May I please, I beg to mention item 26, proceed.
Yes.
In this case, some counsel for days, he is some personal difficulty. So may I pay, may the matter be adjourned for 2 weeks?
You are for the appellant.
I'm for the appellant, my friends appear for the government, honestly for this.
Lordship, I am for the state lordship.
You are for
State of Arunachal lordship.
Honestly.
state of Arunachal.
Lordship.
So what do you say?
Lordship, as my friend has submitted that from council.
Honestly.
What is the problem?
So he's some, the council honestly also, he's some person difficult, he's a lady. So some difficult.
He can't be a lady. We are sure of that.
See,
Land counsel, Mr. So-and-so, proxy counsel, Mr. So-and-so, appearing for
for the appellate.
the appellant. Submits that the lead counsel, MS so-and-so, is not available today. A request is made to adjourn the matter. What is the controversy?
There's some promotion.
Regarding promotion, lordship.
In which services?
Lordship is state.
State services. Who are for the private? There are 29 private respondents.
Lordship.
You represent,
No, lordship, they have been served upon the notice, lordship.
but no one is appearing.
No, lordship.
List after 3 weeks as played.
Obliged.
Other side has no objection list up.
Obliged.
Hey, please, your lordship. I beg to mention item number 21, with the consent of the other party, my lord, the matter may be adjourned for 2 weeks.
But you have not submitted any adjournment request, Mr. Counsel.
My lord, my senior is actually unwell, my lord. He has to be hospitalized. my lord.
You are for
The respondent statement for transport department.
and counsel, Mr. So-and-so appearing for so-and-so. Praise for time. Who is for the appellant?
My lord, S. Samoa, my lord, A. Samoa.
But I am for the private respondent, my lord.
It's okay. Whether the appellant's counsel you are informed,
My lord, I informed.
the appellant's counsel has been informed,
My lord, it may come up after 2 weeks, anything.
list up 2 weeks.
I prefer a fixed date, my lord. In this case,
You need a fixed date.
my lord.
List on 7th June,
It may come on 6th June, my lord.
6th June. You have an objection in everything.
No, no, my lord. Oh, yes, my lord.
Lordship, I beg to mention item number 23.
23, yes.
Lordship, I am for respondent, sole respondent,
Hmm.
22 and 23.
Hmm.
Lordship, my senior is unwell, still unwell. So kindly pass over the matter.
It is stated the arguing counsel, Mr. J. Roy,
Yes, Lordship.
is not well. Request is made to adjourn the matter. List up.
I am for the appellant.
Deeply observed.
Appellant's counsel has no objection.
May I please, your lordship? With the consent of the other side, I beg to mention item number 35 of today's supplementary list, my lord.
Hmm.
My lord, in this case, my lord, last Friday, my lord, department has filed an affidavit, my lord. We would like to file and reply, my lord. 1 week time may be granted, my lord.
And counsel for the, you are for the appellant.
Yes, my lord.
Appellant submits that affidavit on behalf of the respondent department has been filed shortly year end before, and he needs some time to seek instructions. This was fixed at your request. List up 4 weeks as break.
My lord, 1 week maybe.
No, not then. It was fixed on your request.
My lord, the affidavit.
No, my lord, the affidavit was supposed to be filed on 2nd.
Hmm.
As per the lordship's order, they
Hmm.
filed it last Friday,
Last?
Friday.
All right.
That's
List
why,
up
my
to 1 week.
1
All
week.
right.
Obliged, my lord.
Lordship, I'd like to mention for item number 31, I'm appearing for the respondent number 1 to 10.
Hmm.
Lordship, I'd like to seek adjournment on grounds of my senior.
Why?
Yes,
Why?
sir. Due to ill health, your lordship.
The matter of 2021 It's really unfair. A request is made by Land Council Ms. So and so, appearing for Shri so and so, to adjourn the matter on for personal reasons. List up 2 weeks.
Lordship, can the matter be fixed on in the month of August, your Lordship?
August,
Yes, your Lordship. The learned AG is having some difficulty. She has to come from Sikkim, your Lordship.
Sikkim is not so far off.
She's having some difficulty, your Lordship, that's why.
The difficulty will continue till August.
Lordship, there is, she's occupied, that's why she, as per her instruction. your
She has her calendar full till August. She must be quite busy. Still is strange. List up 4 weeks.
My lord,
Hmm.
praying for a listing of a matter, my lord. It's a contempt petition. It was supposed to list after 4 weeks. It's now more than 6 weeks, my lord. Can it be on Friday, my lord?
Check why it has not been listed. Give the details. The court master will check.
Item number 1 of daily list for orders.
May it please, your Lordship.
Yes.
IIT. Lord, in this case, we are concerned with.
Yeah, can you tell us, Ms. Nath, Ms. Das,
Yes,
this matter after 2015 straight off came up before the court in 22.
my lord.
What was the
initially-
reason?
Initially, issue was that there was, my lord, large scale
Encroachment.
encroachment in the premises, my lord, in the lands of the Guwahati High Court.
Right.
That was solved, my lord. Then presently we are concerned with 2 open spaces in the boundary wall of the High Court compound, my lord.
Hmm.
My lord, those 2 open spaces are in a sense, my lord, they are is a security issue in the compound. Now,
So open
The-
spaces are not encumbered or what?
no, my lord.
Why?
What happened, my lord, the open space just in front of the main gate of the bungalow,
Hmm.
my lord, that is my lord, passage for ingress and egress for 4 households, 4-5 households in that locality, my lord.
Mhm.
They are using that road because
That's the
they,
only way available.
my lord, initially, my lord, this honorable court involved IIT, PWD, everyone, my lord. Initially, IIT said that motorable, my lord, there is a, in the map, my lord, there is a road available. There is a road available from that point to the main Bhupen Hazarika road.
Mhm.
Now, initially, IIT said that we cannot suggest for a motorable road. We can suggest for stairs.
Right.
But this honorable court, my lord Justice Chaya, my lord Justice Koteshwar Singh, Soumitra Sakia Justice, visited the place along with my senior also.
Hmm.
Then IIT filed a revised report that is there before your lordships.
Hmm.
And this report suggested with some precautionary measures for a motorable road.
Okay.
Now PWD is to take a call on this report and, my lord, implement the plan, my lord.
Mhm.
It was filed on 22/12/2022, the revised report of the IIT. Yes, ma'am.
This is where the staff quarters are coming up. That is the land.
Yes, below the, there is already a, my lord, building of stenographer, wherein the stenographers are stationed, my lord.
Mhm.
By the side of that building, there is a road. In the map also, that road is there.
No, we are asking, this is the land wherein the staff quarters are being constructed.
Yes, my lord.
The location is that only.
Location is that, just in front of the main gate of the, my lord, that compound.
All right.
The road goes through Malibagan. 4/1/2023, lordship will kindly order dated 4/1/2023.
Yes, the report. The report was submitted on 6/2/23. You have it, Mr. Nath?
Report was submitted perhaps on 22/12.
No, feasibility study for usage of Karguli Road.
Yes, yes, madam.
Yes, that is.
Yes, madam. That is the report.
You have the report?
Well, the report I don't have, but the communication after the report. Well, there is a communication, well, kindly see, well,
What communication from?
communication from the PWD to the head of the department, civil engineering department of IIT Guwahati.
Mhm.
Well, the copy I have given, well.
Yeah.
Well, they said that with reference to the subject cited above, I have the honor to inform you that the undersigned received one copy of the report from the Registrar General of the Honorable Guwahati High Court
Mhm.
on the subject cited above, prepared by the Department of Civil Engineering, IIT Guwahati. In this regard, you are also requested to furnish the detailed cross section and long section of the road so that the construction of the road could be executed on site. Moreover, the above cross section and long section will also enable in assessing the details of land acquisition required for the said construction.
So keep your officer present tomorrow. Keep your officer present tomorrow. We'll just try to have a dialogue. Let's tomorrow, who will be the officer?
Well, the head
Chief engineer,
executive engineer, PWD, he has written the letter. Malad.
executive engineer, so and so shall remain present in the court.
DPO.
Matter number 2.
Would someone had made a mention?
My lord, here, my lord, what happened, my lord, I am the private respondent, my lord, I got implicated in the case, my lord. As respondent number 8, 9, 10, 11.
Hmm.
My name has not been shown in the cause list, my lord. So we could not have filed our affidavit in time, my lord. So may I pray, my lord, a date may be fixed, my lord, so that we can file our affidavit.
Just hold on. This is regarding the delineation of the Panchayat boundaries.
My lord,
All
we
right.
are the resident of that area, my lord.
All
We are the,
Then counsel, Mr. So and so, your good name, please.
my name is J.I. Barbaya, my lord.
J.R. Borbaya puts in appearance on behalf of
Private respondent number 8, 9, 10, 11.
respondents numbers 8, 9, 10, and 11. He submits that his name is not shown in the call list and thus, he could not complete his instructions. Rested to do the needful. In any event, Mr. State Counsel, who represents the state department? No, this decision was taken almost 6 years back. Many changes have taken place in the meantime. Why doesn't the state reconsider? There are many decisions now in between to change the district boundaries also. Districts have been merged, there have been changes. So the order is a state.
My lord.
By flux of time, things have changed. Why don't you reconsider the things?
My lord, as I've already told earlier that senior standing counsel was supposed to appear in this matter, my lord.
Who is he?
Mr. Kumud Pawar, my lord.
When will he come?
I think
Tomorrow?
the gentleman only-
Day after tomorrow?
Tomorrow, day after tomorrow.
Or day after tomorrow? Because this can be closed by directing that the excise may be reconsidered if so required.
After hearing all the parties.
Yes.
That will do, my
It's a long time now.
my lord.
Matter number 3 and 4.
Yes.
Your lordship, ऐसे kindly method pass over बताएंगे. My senior Lexon, what number 2?
So, Mr. Nayak,
Okay.
what have you done for compliance?
Lordship, just like any other person's lordship, she is also getting the same benefit, lordship.
She is already.
Yes.
Have you placed the documents on record?
No,
Have you
this-
placed
No,
the orders on record
lordship, I have filed one affidavit, lordship.
on
No, lordship,
25/8/22?
No, lordship,
Read-
her grievance is that initially,
Her grievance that has been decided by by the court.
yes, lord.
Now the issue is regarding compliance. What is the direction
We are-
given?
We are paying, lordship will see, kindly see the judgment, lordship.
Page 25.
Judgment to Ghana, no?
To give them minimum of pay scale, that is the direction.
Yes, lordship.
Yes,
Lordship,
and they will not be entitled to pension,
they are not entitled to pension.
neither pension nor regularization.
Yes, but our grievance is that lordship will find that page number 26 of the contempt case, lordship.
Mm.
Lordship, in terms of the honorable division bench order, lordship, this notification was issued by the finance department.
Yes, this was referred to in that stenographer matter, most likely. Yes.
Lord,
Hmm.
lordship will see serial number 1, lordship.
Yes.
Let me read the whole sentence, lordship. The following is hereby notified in compliance by all the state government departments
Mm.
applicable for the master role, workshops, casual and similarly placed employees
Mm.
were appointed prior to FRBM that is 1st September 2005.
Mm.
So and so minimum pay scale, pay 1, 12,000, 37,500.
Great pay, medical allowance, dearness allowance,
Lordship, subsequently under this notification, Lordship, they were entitled to minimum pay scale plus medical allowance plus DNS allowance and HRA lot. Subsequently, Lordship, the language was changed at page 28, Lordship. Now, Lordship, under
Fixed
same
remuneration.
yes, here, Lordship, they have been instead of the scale, Lordship, their pay has been fixed at the minimum of the pay.
Minimum. That was what was required actually. That
Yes.
was the intent of the order.
Yes,
You
Lordship.
could not have given them pay scale as such.
Yes. Subsequently, we
Minimum
realized that, Lordship. And
minimum band.
subsequently, we realized and on realization, this notification was issued. Now they are getting 15,900 plus
With DA.
plus MA.
Yes.
And the total is around 23,000, Lordship. Now she is agreed by this order, Lordship.
Then
And
he has to
according-
challenge it as per law.
Yes, Lord.
That order can't be seen in contempt. Anyhow, pass it over. That's-
The number 5,
Service. Service has not been completed.
Yes.
So you need, you want us to give a direction for fresh notice? What is the office note?
9/5/2023.
Notices issued to the respondent have not been received. Notice issued to the respondent has not been received after service. Fresh steps be taken within 3 days, whereupon, notice be again issued to the respondent. Rule is made returnable. The requisites be filed in 2 sets. One set be forwarded by ordinary process and the other by registered AD post.
Lordship, interim order passed on 23 of January may continue.
What is the interim order?
Stay of the proceeding.
What is the order under challenge? Diverse.
Yes,
Why do you need a stay? Section 15 is there. There is no need to pass a stay.
because there is a probability he may marry
Sir, read
again.
section 15, please. Hindu Marriage Act. Then I'll in view of clear language of clear mandate of section 15 of the Hindu Marriage Act, there is no requirement for passing any formal order of stay on the impugned judgment and decree, whereby, the marriage of the appellant with the respondent was dissolved. Thus, the stay application is disposed of. There is no need, Supreme Court says, and otherwise statutory provision is clear. Read. Filing of appeal is by itself a stay. If he enters into matrimony, that is void. Read, please. The appeal should be filed within limitation. That's all that requirement is. You got it?
Yes,
Then why you need stay?
the probability of remarry of the.
Even if there is a stay, he remarries, what happens? The effect of that marriage is nothing,
Yes.
nullity
Of license.
by virtue of law. All right. I dispose of.
the number 6,
एक line लिख देना. As the appeal was preferred in time, in view of clear language of so and so. Yes.
Lordship, there is a substantial compliance, Lordship. Now we are sending the pay slips through email. Lordship, on last occasion, we have submitted the.
Let Mr. Nair come. Let Mr. Nair come. Pass over.
the number 7,
May I plead your lordship? Lordship, I am appearing for respondent. I need 1 week time to file our objection against the interlocutory applications filed by the appellant.
Interlocutory application is for condonation or delay.
Yes,
Yes,
lordship.
madam. 57 days, my lord.
Then Councillor MS so and so puts in appearance on behalf of the respondent.
Hold it.
Hmm. 57 days. If praise for and is granted 2 weeks time to file an affidavit in opposition in the interlocutory application number so and so seeking condonation of delay. Objection kar dena, objection affidavit. 2 weeks. Let's start.
My lord, may I pay for fixing the date, my lord?
Let's on 6 June. Don't mention 2 weeks. Let's start 6 June. Yes.
Letter number 8.
Please, your lordship. Lordship contempt matter. Lordship, the order stands at page 13 and 14, my lord. My lord, the order was passed with mutual consent of both the parties where they come up to an arrangement. Thereafter, pensionary benefits has to be released and that has to be deposited in the bank account. Now, the manager of the bank account, we have given him a formal letter also, that is in page 17, my lord, 16 and 17, annexure 2 of my petition. 59 days have crossed, my lord, but we are yet not able to invoke any response from the respondent. Like, you know, from the respondent. The
Which
bank.
respondent?
The bank, my lord. Chief
Was he
manager-
a party in the proceedings?
But my lord, this order was stated that we have to communicate this order to the bank and thereafter. he has-
Read.
My lord, may kindly be with me in page 14. Number 6, para, my lord. A copy of this order may be furnished to the manager of the concerned bank by both the parties so that the aforesaid terms and conditions mentioned of the order as agreed by the parties which form part of the order are duly complied with by the bank as regard to the money which was received or will be received by the respondent 6, which will be transferred in equal proportion.
There is a further direction that respondent number 6 will also take some steps.
I am respondent number 6, my lord.
You are respondent number
I am
6.
respondent.
You've done it.
My lord.
So the amount was to go from your account to the account of the appellant, or you were to receive.
My lord, the arrangement was such that the pensionary amount would be disbursed, and now that the account is also inaccessible, we are not even sure that the pensionary amount includes the benefits also. So I'll not pay anything in that matter here today. But
No, issue is to whom was the direction? The respondent number 6 was getting all the benefits.
no, it was equally to be divided between the respondent and the
Understood.
petitioner.
All right.
So the bank was to be supposed to bifurcate the amount.
Read para 4 subclause 3. The respondent number 6 will give half of the same to the petitioner.
My lord, but later on the order states that it has to be bifurcated in equal to halves, my lord. The bank should do it.
You have been, you are the respondent number 6.
My lord.
So the pension amount, the entire amount will be received in your account.
My lord.
And then it will be disbursed to the.
The bank accounts also clearly mentioned in para 5 of the order, my lord.
So what is your grievance? We don't understand.
My lord, my grievance is that the amount of pension has been released by the department. But
In whose account?
in my account, my lord.
Then
But they are inaccessible by me,
you are not able to access it
my lord,
on account of this order.
on account of this order, my lord.
Issue notice heard, issue notice to the respondent.
Okay.
Steps for service be taken within 7 days. Whereafter process be issued. Rule is made returnable in 3 weeks. You want dusty service?
My lord will take the.
Dusty steps, dusty service is permitted.
Letter number 9.
May it please your lord. Much of a delay of 49 days have occasioned, my lord, in filing the present writ appeal, my lord. So the grounds for condonation are twofold, my lord. Well, firstly, my lord, the judgment, the impugned judgment was passed in the open court on 14/2/2023, my lords. But thereafter, my lords, the judgment was not made online. In fact, there is a representation by one of the respondents on 3/4/2023.
When did you apply? There must be a detail
There's
of
one
copy
mistake,
applied
my-
and copy delivered.
Yes, my lord. There's one
You filed
mistake.
the application only on 3rd
Yes, my
April,
lord.
then
One mistake, my lord. We filed the certified copy, applied for the certified copy later. No, no,
Then-
what happens nowadays, my lord? We first wait if the matter is online, only then we apply. But there is a mistake, my lord. And second ground, my lord, the petitioner is a headmaster, my lord. He belongs to a small district called Majuli, which is around 300 kilometers from Guwahati, my lord. That's why some time, my lord, was taken, my lord, in filing the appeal, my lord. 49 days, the petitioner is representative, my lord. He's on caveat.
Who is there for the petitioner?
His name is shown in the cause list, my lord. He's there in caveat.
Who is appearing?
B. Das.
BK Das. Let's wait then. Pass it on. Call Mr. BK Das.
Item
What
number
is the
10.
appeal about?
My lord.
What is the, on merits, what is your matter?
My lord, there is a provision of appeal, my lords,
Yes.
in the 2017 rules. Now, what the learned judge, my
No,
lord,
no, we recollect.
my lord.
Item number 10.
Entire case has been discussed on merits and then we say that court was पूरा merit पे लिखा दिया फिर कहते हैं merit statutory appeal बताइए. What is the use of the appeal then?
Well, just a criminal appeal with a miscase. we have
Whether the victim is a party or not,
Yes, we have
Victim
made
is
a
made a
party.
party.
service
Notices were not issued.
not issued. So we'll have to issue
Notice issued, my lord.
notice.
21/1/23, my
Not
lord.
the IA. In the criminal appeal, now what had happened, I've apprised your lordship on the last occasion, that there is a notification of the Guwahati High Court that it is not mandatory to serve notice on the informant. And as per that notification, Guwahati High Court rules was amended.
437,
But they,
439 capital A,
otherwise also
Yes.
by it's mandatory because of the POSCO, my lord.
precisely.
Even POXO is referred
Yes,
in that
That's,
notification.
that's right.
And then,
So we'll issue notice of this
Notice for a
application.
fresh, will
Uh,
take steps on the
Yes,
case, my lord, as well as. the
Uh,
appeal.
issue notice of the IA number so and so, as well as of the criminal appeal number so and so to the
appeal notices are issued,
Appeal
notice.
notice issued, LCR has come, my lord.
but not served.
Notice has not been served, no.
Yes.
Notice issued to the victim respond number 2 in the main appeal has not been served. Let fresh steps be taken within 3 days, whereafter process be again issued to the victim of the appeal as well as of the application for suspension of sentence.
Even after
The-
that amendment, lordship, there is a step taken by the Guwahati High Court. We were told by Justice Jatang Kumar that even Supreme Court judgment was referred. That
Where is
Justice
that notification? Can you show it to us?
notification is there along in the,
Dena?
in fact, in the Guwahati High Court rules, it is amended. And even after that, some steps were taken because Supreme Court judgments came by then, 2022, saying that the victim needs to be heard at every stage, even
That's
in
right.
bail. But that also was referred by the Honorable
That
High
is
Court.
A little too much to expect that in every bail application,
Yes.
victim should be heard, but yes,
Ah.
POXO, there
POXO,
cannot be any two views
yes.
about it.
The
So
lordship can-
we'll
yes.
appropriately read down that notification, just we'll have it and
Lordship,
read down so far as the POXO cases are.
So far as possible.
Yes. Oh, nikal dena notification.
I'll take out that Guwahati High Court. rules and I'll-
The notice being issued to the respondent number 2 shall also contain an intimation that in case she is unable to engage a counsel of her own, the Assam State Legal Service Authority shall provide services of a legal aid counsel for contesting, representing her in this appeal, as well as the application for SOS. Rule is made to on. Service be got effected through the investigating officer concerned.
Yes.
Thus, the notices be provided to learned special public prosecutor. List on 14 June,
Lordship.
14 June.
Item number 11.
Same is the case here also.
Same.
But in the appeal, notices are issued, unserved notice has returned.
Notice is returned unserved.
Yes. In fact, in the
Is
IA,
it changed,
no
Kamana?
notice has been served.
I no notice.
IA, no notice has gone. There's no order for notice in that.
We'll issue now. Notice issued to the respondent number 2 victim in the appeal has not been served. Then same order. Gunajit, same order
IO will do it. Lordship.
through the IO.
Yes.
Rule returnable on 16 June.
Lordship.
Obliged.
Obliged.
Item number 12.
Who is representing Union of India? On the last date also, no one came. Does Mr. Arkadidev Chaudhary know about this? On 20th February, again on 20th March, no one. None present. On previous 2 dates also, no one was representing the Union of India. Dismissed for want of prosecution. Call Mr. Chaudhary, let him know. Maybe this. Is Mr. Goswami a central government council? Call Mr. Chaudhary. Mat karna aur don't do it. Yes.
Item number 13 and 14.
Lordship on last occasion has asked me whether there is compliance of the order dated 21 for Lordship 22/11/22 Lordship. So they have asked for 3 more days time Lordship. Most probably this has been complied Lordship, but they could not communicate to me Lordship.
MSM Bhattacharjee praised for and is granted further opportunity of 7 days to apprise the court regarding directions given on 24 steps taken in pursuance of the directions given on 21/4/23 list on 21st June 22nd May.
Deeply applied.
Right.
The number 15.
Where is Mr. Saikia? We had given direction to constitute a PLPC, Public Land Protection Cell. What has been done for that? Call Leonard AG. वो PLPC वाला order निकालना है. Close in that environment better. What has been done? This is a case wherein we can give that direction. Pass it over. The time.
Item number 16.
May it please your lordship. But in the read proceeding, my lord.
There was a remand to the appellate authority.
My lord.
The order under the impugned order, the matter has been remanded to the appellate authority.
My lord.
What happened?
My lord, that is pending. My appellate order was set aside.
That's what we are asking.
That is
Whether the
pending.
appellate authority has taken up the matter again.
Yes, your lord.
What has happened?
It is pending, your lord.
It's pending.
So let's wait for the decision.
My lord, we have, no, my grievance is, my lord, that my primary challenge, my lord, has been negated by the honorable single judge.
Regarding the locus of the inquiry officer.
Inquiry officer.
Whether he's a public servant or not.
The other day, my lord referred to section 197. And particularly to the word was. To give an impression that a retired public servant could also be a public servant. And lordship, my lord solicited my response to that. My response would be as follows, my lord.
Yes.
My lord, 197, my lord.
Yes.
Doesn't lay down any general proposition that a public servant, even after retirement, he continues to be a public servant. In fact, the statement of law is exactly the opposite, my lord.
Have you read the judgment of Dr. Buddhi Kota Subbarao?
My lord, only, my lord, by way of legal fiction. Legal fiction, my lord. In section 197, a retired officer was deemed to be a public servant, notwithstanding his retirement. May I just refer one paragraph from Buddhi Kota Subbarao, my lord. 93(3) SEC.
Yes.
Page 339. Para 8. What remains to be examined is if the documents which were found in possession of the accused and were collected or obtained by him when he was in service were procured by him in discharge of his duty. But before undertaking this exercise, it may be stated that section 197 of the code, as it stands after 1973, extends the protection even to a retired public servant as is clear from the use of the word is or was, provided the acquisition is in respect of an act or omission done or purported to have been done when such public servant was in office. By legislative fiction, the officer is deemed to be a public servant under section 197 of the code, irrespective of his retirement.
All right.
So my submission will be that legal fiction will be only limited to the
But there is a-
purpose for which it's created, my lord.
Because of the word was.
My lord. So it was a legal fiction, and it should be confined only to the four corners of 197. So this 197 cannot be placed in the service.
Right.
He said that.
And what is the provision on which you are relying upon? What is the provision of the rules?
My lord, this public servant has been defined.
No, please read the provision of your service rules wherein,
My lord, this,
as per you, there is an embargo on a retired public servant
my lord,
being the inquiry officer.
my lord. Regulation 6(2), my lord.
Is it reproduced anywhere? Is it reproduced in the order?
No, man, I'm just providing. my lord.
They know.
Regulation 6(2), my lord. It gives a discretion to the disciplinary authority either to inquire himself or appoint any public servant. Now, this public servant has been defined under regulation 3N, my lord.
3N.
3N. To mean a public servant as defined in section 21 of the IPC.
IPC.
My lord.
Yes.
Section
So the
21.
we have to look at the IPC provisions
My
and clause 6 thereof
My lord.
has been applied by learned single judge.
My lord.
What is wrong in it?
I will come to that, my lord.
Yes. Any interpretation made of this clause by any court?
No, in fact, my lord, the learned single judge relied on Alok Kumar's case, 2010 5 SSC 339, my lord. There, Supreme Court was called upon to interpret the word other authority, appearing in Rule 9(2) of Railway Servant Discipline and Appeal Rules 1968. That is other authority, my lord. Now here, section 21, Lordship will find, it says that the word public servant denote a person falling under any of the description hereinafter following, namely so and so. There are 12 description invoked clause 6. Lordship will find clause 6, every arbitrator or other person.
Yes.
Now, Honorable Single Judge, my lord, he concluded that a retired person, by virtue of being another person, he will satisfy clause 6 of section 21.
Yes.
My lord, my response will be like this, my lord. Now, my lord, this arbitrator is a specific word, my lord. It pertains to a definite class or section. It has definite connotation, my lord. Arbitrator is the person to whom a dispute has been referred for decision. Now, other person is a general word. So this general word is to be construed Yosdim generis to the preceding specific word, arbitrator.
The basic concluding part of this provision is to whom the matter has been referred for decision or a report. The arbitrator doesn't give a report. Report can only be given by an inquiry officer. So that is why you will have to read these two words in isolation.
Here, this any person or a report is the person that is section 133 of the CRPC referred to, or 145, 147, 148. But this report, my lord, will not include a person who giving a report of inquiry report in a disciplinary proceeding.
And you see, there is no adjudicatory power given to the inquiry officer. He simply collects evidence and presents it to the disciplinary authority. Ultimately, the job of it's an outsourcing kind of thing. So what prejudice is caused to you? Let us know.
My lord, my response would be that this order, he has absolutely no jurisdiction. It's an order without jurisdiction, my lord. It's a nullity because this section or regulation 6.2 says public servant. If he is not a public servant, my lord, he has no jurisdiction. His order will be without jurisdiction. It will be nullity. There is no question of, my lord, prejudice comes in, de facto prejudice.
Let's know what prejudice. You see, recording evidence on commission, the court grants it. So the person who is recording evidence, he is not a judicial officer, but he records evidence for the court. Is that evidence not admissible as per the Evidence Act?
No, my lord, in the teeth of regulation 6.2, in the teeth of regulation 6.2, it specifically says public servant.
Prima facie, that's in definition of public servant as provided in 21. That would include every clause of 21. Prima facie, we are not satisfied, sir. We want to take a chance, still we can give you an opportunity. That's what we'll say. Otherwise, we'll decide it. Let the appellate authority decide things on merits.
Even otherwise, my lord, my appellate order has been set aside, they will decide it. But had this plea been accepted, even the
all right, then
authority would have
all right, then argue. We'll decide it on merits. We'll take note of your argument that the preceding, the subsequent term, other person has to be governed by arbitrator. That's your argument. Second argument, you just them journalists. Yes, we'll consider that. What more?
Even otherwise, I'm saying, my lord, that 197.
197, all right, we are satisfied now.
My lord. My alternate argument will be, my lord.
Yes.
That this 76 regulation under which I was proceeded with, my lord, it was framed under section 19 of the Banking Companies Acquisition and Transfer of Undertaking Act. Now, section 14 of the Act creates a legal fiction to the effect that only a just a minute. Madam,
What about the law as laid down in Ravi Malik?
Ravi Malik says, my lord, that the retired person will not be a public servant.
Will not be?
My lord. That is Ravi Malik, my lord. Moment a person retires, he ceases to be a public servant. That's the law laid down in Ravi Malik, my lord.
There, the language of the statute, the relevant rules was different.
No, I admit that in Ravi Malik, this term has not been defined.
Other, yes, term, it was not provided that the public servant would mean the public servant under section 21 of the IPC. So that is a basic fundamental difference.
Yes, yes.
In Ravi Malik, yes.
Now, in section 14, my lord, so far as this legal fiction is concerned, my lord, to the effect that only custodian of the bank will be a public servant for the purpose of chapter 9 of the IPC. Now, custodian has been defined under section 7 of the Act, 70 Act, my lord, to mean a chairman of the bank. So, as per the enabling Act, my lord, only a chairman of a bank will be a public servant, that too for the purpose of chapter 9 of the IPC, not otherwise. Now, this 76 is a subordinate legislation, my lord. My contention will be this subordinate legislation cannot extend the scope and ambit and the width of the parent act.
Right. So now you are on challenge to the rules or the regulations.
No, my lord, there is no chance. I admit there is no chance. Well, in fact, I didn't carry the book. May I just pray for some other day, my lord?
Arguing for 15 minutes.
I'm sorry, my
It's
lord.
very unfair.
I'm extremely
Absolutely unfair.
sorry. I'm extremely sorry. I didn't carry.
Arguing the matter for some time
I
and
carried
council,
wrong
Mr.
book.
So-and-so. Please for time. List after 4 weeks. In the meantime, the standing council for the bank shall instruct the appellate authority to expedite the proceedings of the pending appeal. Hello. Give that regulation back to council.
The number 17.
Rupam, give those regulations back to London council.
May I please, Lordship?
Yes.
A private dispute is going on between the parties, my lord. A title suit has been filed.
Yes.
Now, my lord, that rate code has been invoked and my lord, order has been obtained. Now, Lordship has already decided the issue in one, against my case, my lord. I want to take the advantage now from this side, my.
Pass on that judgment, please. What have we decided?
Well, Lordship clearly says that civil remedies, my lord. Other than that, it's a very severe dispute. My injunction petition is the other that become infractious, my lord.
Yes.
Another copy, lord. Please.
Land council, Mr. So-and-so frankly concedes that in view of the ratio of this court's judgment in the case of Shivnath Singh, and as the parties are already embroiled in a civil dispute before the civil court, there is hardly anything to adjudicate in this appeal. Hardly anything is left to adjudicate in this appeal, which is directed against the impure order rated so-and-so, whereby, the APDCL was directed to afford
Temporary connection.
temporary electricity connection to the writ petitioner, respond number so-and-so. In view of the submissions noted above, will not impute it to you, don't worry. We'll mold the order accordingly.
My lord, it has to be set aside, my lord, that single bench judgment.
Why?
Because I'm against this judgment, my lord.
You are against?
Against this judgment, my lord.
A judgment to the extent?
My lord, that the learned single judge is allowed in a read court to restore the electricity connection.
Electricity connection is essentially a civil right.
Understood. My lord, that is
No.
the reference that has been made. My lord, in
No.
my lord, tenant. And he's not a tenant as on that. My lord.
That dispute is to be seen by the writ court,
Exactly,
by
my
the
lord.
civil court.
Exactly.
So presently the dispute is whether he is entitled to amenities or not.
Amenities.
So it's entirely a different dimension to
My lord,
this.
kindly see, my lord, that the reference is only one judgment, my lord.
You give whatever judgments you want, yes.
My lord, the reliance which has been given by the learned single judge, that is also emerged from my lord civil court, my lord, order, my lord.
Give it.
Paragraph 5, my lord.
Yes.
Kindly see, my lord, it is not a read code which has been invoked, my lord. That paragraph 5 clearly say the petition was filed for restoration of electricity connection, my lord, to the rain controller.
Yes.
Paragraph 5. Then, my lord, where is the scope for my lord invoking, my lord, 226, my lord? The reliance which has been given by the learned single judge, emerged from, my lord, this judgment, my lord.
Let's see your prayer in this appeal.
My prayer is, my lord, to stay the further operation of
Page.
my lord, page 32, my lord.
Read.
My lord,
Page 16, my lord.
page 16, my lord.
16.
My lord. My lord, everybody otherwise.
Just hold on. What was the original order of Senate Court?
But that contained in page, my lord, 134, my lord.
34.
134.
134.
My start from one page 130, my lord. Start from 130.
Just hold on, sir, hold on. So where is the order dated 29/3?
My lord.
29/3 order dated 29th March. This is an interlocutory application. This order has been passed.
My lord,
Where is the original order? That is not challenged.
That we have challenged, my lord, that
Read the prayer. That is why we asked you, sir. 29/3. Where is your prayer?
my lord, my prayer is in respect of IA, that is 993.
Sir, so original order is never under challenge.
My lord, that is 135, my lord, page. 135 is the original order.
135.
130 is the order intellectual order final disposal. Lordship, can you-
Sir, the application was filed to set aside the order dated 29th March 23.
My lord.
Where is that order?
My lord, my challenge 12 my lord.
Sir, where is that order we would like to read?
My lord, page 130.
130.
Order dated 12.
Order dated 29th March.
Good. It's not there. That is initially passed, thereafter we challenge. I'm giving my lord.
The relief was granted to the respondent by that order.
Initially, my lord. Thereafter, my lord, finally relief was granted by virtue of 12/4/2023 order, page 130.
Mhm. 87.
87, my lord. Initial
Yes, read that. That is an interim order.
order. Yes, my lord. That we put on the challenge.
All right. Hmm. All right, what is wrong in the order? Let us know.
Lordship.
Yes. That's a dispute. This judgment you are relying upon was not a dispute of electricity connection.
But question is that, my lord, can you see the reliance wholly given to the judgment of my lord, Dilip Dev versus the Satish Kumar's case 2012
Yes.
SCC, and my lord, paragraph 5 clearly said, Lordship, can you look? It is said, under section 70 of the Hyderabad Rent Control Act, in the court of the rent controller, the Aurangabad seeking direction on the appellant to provide electricity connection.
Yes.
Therefore, it was put under civil court, my lord, that jurisdiction was exercised, my lord. My lord, division is that, my lord, they have invoked, my lord, 226, my lord.
Who has filed the suit?
We have filed suit, my lord, bring landlord.
All right. You have not challenged this tenancy. You have filed a civil suit saying that he's a trespasser.
Yes, my lord, because.
Why should he go to the under the Tenancy Act
My lord, because Lordship kindly
or
see.
the Rent Control Act?
Yes, my lord. Lordship kindly look that the definition of tenancy is clearly indicated.
At
My lord, in my read petition,
read.
I am giving my lord. (2021) Tenancy Act, my lord, paragraph 18
at page
83.
83.
May I read, my lord?
Yes.
The opposite party number in this read petition has claimed himself as a tenant, and as per Assam Tenancy Act 2021, section 2N of the same define the state definition of tenant as follows. Section 2 and tenant, whether called lessee or by any other name, means a person by whom.
Sir, for you are saying is that he could have filed the application in the rent control proceedings, right? There were no proceedings. Civil court is a different thing. This is under the rent control.
My lord, because my lord, some in other states, my lord,
yes,
that rent controller are appointed to look into the dispute between landlord and tenant. But in here, my lord,
there is no rent control court here.
Till yet, my lord, in Guwahati not formed.
All right.
And lordship, can you see the last line is very important.
Yes.
Premises is payable to the landlord under a tenancy agreement. My lord, there is no tenancy agreements after 2021. So therefore, in absence of any tenancy agreement, he cannot be defined or come under the definition.
Oh,
of tenancy,
that you settle in the suit. Not satisfied. You can't intervene in the electricity connection under the garb of this proceeding.
My lord, can you see another aspect that temporary
Yes.
and connection cannot be given to my property without my consent, my lord.
Yes, so you seek an injunction thereupon.
My lord.
You seek an injunction against that.
My lord, that's why my lord, read court, my lord, already passed an order.
All right. Admit no ground is made out for grant of stay, prayer for interim relief dismissed. We'll examine it academically. Steps for service be taken. So you represent
Respondent number 225.
APDCL.
APDCL.
For be taken for respond number 1, be taken within 7 days, whereafter process be issued.
My lord, deeply. Deeply.
You have not made any prayer at all for interim relief.
My lord, I have made, my lord. My petition, my lord.
There is no separate application, that's why. All right.
Deeply.
Matter number 18.
Neatly, your
Serious matter.
This is that matter, mob lynching matter of Teju. My lord, they will discharge.
Court is
them
monitoring, my
status.
lord, this.
Is there, we just want to know, while it was, whether there is a, the CCTV is installed in all police stations in Arunachal?
At the relevant time, my lord, no.
No, as on date.
As on date, my lord, that instruction we have.
We want you
At that
to,
point of time also CCTV was there.
were there,
The miscreants took the entire, my lord, the box and the CCTV,
they snatched it away.
and the police could not recover that, that also.
Yeah, but if there is a centralized setup,
Yes.
then the data is stored there.
Stored, my lord, but there
Even
is
if
nothing-
someone steals the things at the
Yes.
local point,
Yes.
then the data will be there in the central server.
CCTV was installed at that point of time.
It
but
must be
that-
locally used.
Yes,
Whether there is a centralized system,
that my senior will be.
That status we have taken.
otherwise we are directing you to install an absolutely the connective CCTV system in all police stations.
My lord.
Then that has to be joined through a central server.
My lord.
Now you have the means. The internet connectivity is there.
Yes.
Just now,
Even in this case, my lord.
yes,
They took out these accused people from the police station, that is one issue, and then leans them brought them in the middle of the road. So if cameras were there, my lord.
and those people have been discharged.
Yes.
That is shocking part of it.
Under 302, they have been discharged and they have been.
You have filed a petition, we suppose.
Yes, my lord.
State has
Against
filed,
that, my lord.
state has filed.
Status, my lord, these are the copies, last copies, my lord.
Let's see.
But one thing I would, I don't know whether this court will go into that aspect of the matter or not. But they are evading their appearance before the High Court. In
The
criminal
discharge
petition.
accused.
Yes, criminal petition, my lord. They are still to appear. On one occasion,
And
the,
steps have been taken on 1st of May.
yeah, I got order to.
No, but just let us know whether there is a full discharge or a partial discharge. So then you get them served in the trial court. They are on bail.
Yes, my lord. Steps have also been taken, my lord.
On one occasion, it was served to the concerned commissioner of police, I think, but thereafter.
The accused are on bail. They are
Yes, yes,
facing
they
trial
can
for
get-
remaining offences.
Yes, yes.
They can get them served.
Yes.
All
yes,
right.
yes.
This court is informed that the service of notice of the criminal petition number 118/2022 within bracket filed before Itanagar bench has not been effected on the respondents accused who have been partially discharged by the trial court. First up, by the learned Session Judge East Sessions Division Teju. First up. As the this court as is evident, these accused have not been fully discharged,
Yes.
in all probability, they would be facing trial and
It's
are
running,
reportedly on bail.
well, it's running in the court of judicial magistrate first class.
Trial in the court where the
Yes,
matter has been sent after being toned down.
yes, my lord.
Thus, the service of notices is required to be effected before the trial court where these accused are now facing trial. The learned Additional Advocate General shall ask his counterpart to do the needful positively within next 4 weeks. Counterpart in the trial court kar dena. Counterpart of the public prosecutor concerned. This court further feels that in view of the nature of allegations for which this suo motu PIL was registered, a direction is required to be given for installation of a comprehensive CCTV system in all police stations across the state of Arunachal Pradesh, with the data being monitored by a centrally located server system. Thus, Additional Advocate General Mr. Goswami shall take requisite instructions for compliance of this direction. Mr. Saikia, is there system prevailing in Assam? CCTV, there has to be there in every police station. And in order to ensure that merely because the system at the local place is taken away, the things do not get wiped off, the central server works. The data always remains. Is it there? You find out.
In the hospital we have, but police
Stations is absolutely essential now.
Hospital
More because now you find so many cases of violence
against the
or atrocities.
against the doctors. Yes.
No, atrocities in the police station. If the CCTV is in place, these things will definitely be
Lord, I'll
checked. You find out, let us know.
Lord,
So-
satellite assisted may also be satellite assisted in that.
So you just find out, if need be, we can incorporate this order or expand this order in Assam also. Or we'll take it up in some separate matter.
Lord,
But you find out,
I'll find
it is good for everyone.
Yes, Lord.
Yes.
Supposing false allegations are leveled against policemen, they can show the footage.
Lord. Otherwise, police are very cautious nowadays. Lord.
But it's better to have a
Yes, Lord.
CCTV installed for surveillance. It's always better.
Highly obliged.
List on 4 weeks. बाद का date दे देना. इसमें लिखी दीजिए ना. Learned Advocate General Mr. Saikia, Advocate General Assam Mr. Saikia shall also find out about the status of CCTV systems within bracket if installed in the state of Assam, in all police stations across the state of Assam.
Lordship. Lordship, my name may be reflected in.
Name of Mr. Saikia shall henceforth be reflected as in the cause list.
Highly obliged.
Re-notify on 16th June.
Deeply obliged.
Highly obliged.
Item number 19.
Some SOP in place in Rajasthan
Lordship.
for this.
If required, Lordship,
You
procure that also.
we'll provide you that copy.
Lordship.
Item number 19.
Yes.
President, appeal under the provisions of Central Access Act, my lord. The only issue is that while preferring the first appeal,
Delay was not condoned.
54 days due to the statutory.
Does the tribunal have the power to condone the delay? If not, there you had two matters.
My lord.
One was falling in that COVID extension.
That was given.
That was given. So the other could not have been given.
No, my lord. What happened? The first appellate court said that 54 delay, we are not competent, we cannot. We went to tribunal. Tribunal has condoned the appellate delay and again came to the merit, said the first appellate authority had no power, so it was rightly rejected. The issue falls, my lord, whether that 54 days delay can be condoned or not, my lord. They are being
Sure.
statutory.
Limitation Act is not applicable.
Limitation is not
Then-
applicable, my lord.
Then
My
how
lord,
the delay is to be?
I'll be placing two judgments before lordship, after two judgment, recent judgment, my lord.
Right.
My lord, that period of time, I was terribly sick, my lord. I
Let
was
us see, let us see the judgment you are relying upon.
my lord.
Probably Mr. KL has cited this Singh Enterprises. It's your judgment
That is,
you have relied upon.
that is reflected in the impin order.
Yes.
3 or 4 judgments.
So any contrary view has been taken.
No, no, till that, no order.
My says, my lord, I have two judgments are there, my lord. One is 2017-11 SCC, my lord. Here there was a delay in Income Tax Act, my lord. delay of 14 days.
Inherent jurisdiction, where do we get it from?
Alright.
Inherent jurisdiction to condone delay,
That
where
is
do we get it from?
Supreme Court, whatever I have to catch it, my lord, whatever I get.
Sir, you have to,
Supreme
you
Court
have to
judgment.
satisfy us on these judgments. How do we ignore the law as laid down?
No, my lord, the second judgment.
These are
that I
binding
placed-
on us.
Second judgment that I placed, my lord.
Yes, read
There also, my lord, that,
resorts.
my lord, yes, my lord. The case which has been, my lord, paragraph 8(1), the last page of the judgment, lordship kindly see. Court has said that, my lord, the person cannot be remedied in any given situation. My lord, kindly see 8(1), my lord, as your lordship got it, my lord.
Just a lot.
It has relied upon number of judgment earlier, my lord, but the relevant point here I am saying, my lord, which will be appropriate in my case, my lord.
But this is a scheme. So you just, this is a case wherein the beneficial scheme was there, the party could not apply. That's it. Herein there is a prohibition, there is a restriction imposed by law. Nothing beyond that.
Mother.
The scheme is a semi-statutory kind of thing. The government gives like an incentive. This is a statute. How can we go against a statute?
Your lordship, statutory bar came because the scheme closed. Therefore, scheme closed, and since the party was facing a moratorium, he could not deposit the money. So Supreme Court has said that
This is not a case wherein the statutory provision has been relaxed.
no, my lord, the lordship, the court has given an example in page 8(1), my lord. Paragraph 8(1), last page.
Yes.
My lord, ninth line from below, my lord. In a given case,
Applied under the scheme was ill understood. But that is again not a provision of statute barring an appeal beyond a certain period of time.
So it says that, my lord, in a given situation, if the person is seriously ill, my lord, then, my lord,
You don't read the earlier lines, applied under the scheme,
my lord,
not under a statutory provision. Was ill is a subjective kind of thing.
my lord,
There may be n number of situations. We may rely upon it, we may not. But if the statute says no deviations, there are no deviations. So there is no remedy, there is no remedy. Come out with a High Court judgment on specifically on this point. You won't find any.
High Court judgment, my lord, I have number of judgment, my lord. That GST provisions, the regards of GST provisions, court has said
It's a
that,
new act which has come in.
my lord, my lord.
There are certain uncertainties, but here in this Central Excise Act, there is no uncertainty. The law is crystallized.
My lord.
So there is no scope for condonation.
In my case, what happened, my lord, I was not in a
How do
position,
you
my
get
lord.
out of the ratio of these three judgments?
My lord.
Just tell us.
Yes,
Pass it on, Mr. K.
yeah, I am not mentioning enterprise. I've seen it, my lord.
So then what is to be done? There's no remedy, there's no remedy.
My lord, this judgment, I'll be relying on this last judgment, my lord, says that in case of severe sickness, my lord, is not in a position to do it, my lord.
Severe sickness.
My lord.
All it shows how he was ill.
Well, I said that lordship may kindly consider,
Let's
my lord.
see. Law doesn't account for that even. Law is too harsh.
I have enclosed documents also, paragraph 4, my lord.
Of
Paragraph 4 of my petition, my lord.
appeal.
No, this appeal, my lord, yes.
Yes, para 4 read.
From the
What
beginning-
illness?
No, I'm coming to,
It's
my lord.
very vague. What illness?
My lord, I'm coming to, my lord.
Yes. Angiography stent.
Yes, my lord.
When did you get it done?
My
What
lord,
is the
that
date?
was- That was on 27th of June, 2018.
And what
Then
was when was the appeal to be filed?
No, that is the sickness starting, my lord. Then lordship kindly see, I was shifted to Vellore on 2/7/2019. By ARN, next day I was admitted in.
Referred to CMC, not shifted. There's a big difference in shifted
No,
and
no, I
referred.
got admitted. I have enclosed paper, my lord. Next day, I went by air.
Traveled from Dibrugarh to Chennai by air. So he was absolutely fit. Otherwise, a person traveling on his own from Dibrugarh to Chennai, you have to change 2 flights probably.
Yes,
one at least.
Yes, 2 flights, my lord. One
Yes,
from
so-
Calcutta, my lord.
A person absolutely easily travels to Chennai
My lord.
for his treatment.
But next day, he
And-
got admitted in CMC Vellore, my lord.
Yes.
I have enclosed paper, my lord. He went for only for his treatment, my lord. There was a renal problem, that heart problem.
Let's see your medical. Let's see your medical documents. Annexure 3.
My lord. Annex 3, my lord, huh? Page 29, my lord. Second, he moved, my lord. Third, he was admitted, my lord. TMC, my lord.
Hold on, hold on.
He was even unable to move, my lord. Now he is moving somehow, my lord. Still is continuing to be, my
Unable
lord.
to move, there's nothing in the medical documents. When was your preliminary investigation done? Let us see, which indicated that you require this.
Page 31 is the discharge summary, my lord.
Diabetes, 20 years on treatment. History of present illness. Complaints of acute onset of retrosternal chest pain since 6:30 a.m. today. 30th, that is 27th July. So your original order in original was passed when?
My lord.
You got admitted on 27th July, sir.
My lord.
You went to Vellore on 2nd July.
My lord.
And admission is not on the same day. It's on 22nd, 27th.
My lord.
20 days, 25 days later, sir. What are you talking?
Examination.
Read your discharge summary. Date of admission 22nd, 7th July. What you were doing for 25 days? And your ticket says discomfort on the same day, 6:30. And your order is of 1st May. What you were doing for two months? Nothing.
No, I was continuously ill, my lord. That's why that is my goal.
There is no material, Mr.
It is
Counsel.
not that a particular day.
There is no material. That gap of 25 days, how do you explain? After going to Vellore?
My lord.
Probably you missed the date.
My lord, 83, my lord, my appeal petition, lordship, can you see?
Yes.
Our High Court decision, my lord. In similar case, my lord.
Our High Court decision after taking into account the Supreme Court judgments.
That is also.
So that is per incurium. Will declare it to be so.
54 days, my lord. On merit, lordship, not given a
even
paragraph, my lord.
single day, unless the law permits. Not even a single day.
My lord.
Yes, Mr. Kale. Justify your brief. He was an ill man. Why shouldn't we condone it?
Now, with regard to law, lordship, law is clear and supported by judgments of Supreme Court.
Okay. Law is sterile of illnesses. Okay, very well. Dismissed. This is item number
19.
And this is a company. He is what? Not a proprietor.
No, it's a partnership, but name is given a company, my lord.
We see it as a company. It was a body incorporate. Anyone else could have done it.
No, it is a partnership. I mentioned, my lord.
Dismissed.
Number 20.
In this case, my lord, the petitioners are filing in reply every week, my lord.
Do you want to file a reply?
Yes, my lord. Today they are filing, my lord.
You are filing today?
Yes, ma'am.
The concept for the petitioner submits that he would be filing an affidavit in reply during today.
Madam.
Where is the postmortem report of this man? Have you placed it on record? It has not been annexed with the inquiry report.
Yes.
Mr. Saikya, we would like you to place that on record.
Okay, Lord.
Learned Advocate General shall ensure that the postmortem public autopsy report of the victim
Lordship.
is placed on record by next date. List on. How much time do you need, sir? Up to 2 weeks.
Next week, my lord.
Up 2 weeks.
My lord, deeply obliged. Highly obliged.
Item number 24.
Is there a Human Rights Commission here? Mr. Saikya, is there any Human Rights Commission functional?
Yes.
In Assam?
It is functional.
My Lord Justice Bhaipe was supposed to retire during these days.
Okay.
And the next is also, the government has taken a.
Nomination is done, appointment is done, not yet.
Cabinet, not cabinet, the government has taken a decision.
All right.
My Lord Justice A.K. Goswami, his name is approved.
Okay.
And others were also approved. One vacancy was also arising in the members list.
That's what you are thinking, whether there is any complaint.
Otherwise, my
The
Lord
Human
Justice
Rights
Bhaipe
Commission.
was here there till last month. Whether he has on today, I do not know, Lordship.
Okay.
It is functioning, Lordship.
Very good.
And Lordship was pleased to call me for another matter.
Which one was that matter? That PLPC direction we had given,
Lordship,
whether anything has
I'm
taken
very
place.
sorry to say it was not informed to me, but I will take the information.
We'll reiterate in this order.
Yeah, that is excellent,
We'll
Lordship.
reiterate and we'll instruct you to place the compliance report on record so that
Yes,
the
Lordship.
direction is given.
It was given long time back on 2nd of March.
2nd of March.
Today only I have come to know, Lordship, from
Oh.
my colleagues.
Okay.
So I'll take steps, Lordship, may take up this matter after 4 weeks. In the meantime, I'll do the necessary.
We'll just pass a similar order in this case also.
Lordship.
And in the meantime, you direct that the committees are
It
placed.
will be very effective, Lord.
Yes, all right. We'll dispose of your petition in this line. We'll direct the state government to constitute a public land protection cell. And you file a complaint to the cell, they will take care of these issues.
Right. And if they do not take, then they can.
Then of course the remedy is there
Lord.
to come back. Okay.
Highly obliged.
Disposal. And mark the attendance of Lord Advocate General. Yes. Yes, madam. Yes, Mr. Council.
Lordship, in terms of Lordship direction, Lordship, today the screening committee is going to be held. Lordship may take it after 1 week or 10 days. Lord.
And Standing Council, Ms. Chaudhary, submits that the screening committee would be examining the case of the appellant in coming few days.
Today itself, Lordship.
Today,
Yes, sir.
he prays for short opportunity to place on record the decision of the screening committee, placed after 1 week.
Deeply obliged.
The number 25.
Maybe, as per last order, my lord,
The affidavit has been sent for vetting. My Lord, it should be back by tomorrow. So she will give me 2 days time. My Lord.
Mr. Mazumdar submits that the affidavit would be filed within next 3 days.
My Lord,
urgency on our part, my lord.
it will be on the 4th day, my Lord.
Affidavit is ready and has
Ready,
been
ready.
sent for waiting.
Yeah.
It will be filed within next 2 days.
My Lord.
Re-notify on 23rd May.
The number 27.
May it please your lordship.
Yes.
Lordship, this petition is about the state of affairs in the Consumer State Commission, my lord. About the state of affairs in the Consumer State Commission, my lord.
Consumer, what is the problem?
My lord, there were no funds, my lord, even to buy postage stamps and all. After filing of this PIL, the situation has improved, my lord.
Okay.
But as of now, there is only one stenographer, and of course, there is space constraint. As of now, that is the problem. Only one stenographer for 4 members, my lord.
Yes, madam. You are appearing.
Yes, lordship.
What is your response?
Lordship, about this additional affidavit, lordship, I seek 2 weeks more time, lordship.
And Government Counsel, MS M. Bhattacharjee, placed for and is granted 2 weeks time to take instructions in reference to the additional affidavit submitted on behalf of the petitioner. List up. That affidavit was filed on 5th April. Almost
Yes,
more than
lordship.
6 weeks now.
Lordship.
List of 2 weeks.
Deeply obliged.
The number 28.
Lordship, an affidavit of in opposition has been filed. So I have not voted, my lordship, affidavit in opposition. I want to give reply to that affidavit in opposition only.
And counsel for the appellant submit that he is desirous of filing an affidavit in reply in reference to averments made in the affidavit in opposition filed by the respondent state authorities. How much time do you need?
2 weeks, my lord.
The place warrant is granted 2 weeks time to do the needful list after 2 weeks.
Obliged, deeply.
The number 29.
They don't provide anything to any. They just don't provide. That's why, just just do. They cannot be jurisdiction by court. Now the criminals which have been processed are not good. And very bad state of affairs.
Yes.
May it please your lordship. Well, the appellant before lordship was not a party in the writ petition matter. He was not implicated as a party matter. By the impugn order, the learned single judge at page 33, my lord, has cancelled the selection process where the appellant was selected.
Cancel the selection process. All right.
And the reason is page 37, my lord. Last paragraph, my lord.
Last paragraph of the impugned judgment.
Impugned judgment, page 37, my lord. The learned second judge has presumed that the state government has abandoned the selection process, my lord. In fact, my lord, the writ petitioner filed 2 writ petitions, maliciously suppressing all legal fact, my lord. Even without participating in the selection process, my lord, he has filed the writ petition challenging the selection process.
You were the selected candidate.
I was the selected.
And you were not heard.
I was not even in the party. I was not heard, my lord.
Yes, Ms. Mazumdar.
My lord, the writ petitioner, he did not participate in the selection process, my lord.
I do not have the copy of the appeal, but my lord.
No, my lord, no.
Provide a copy.
I can give it, my lord. It was given. I can again give him. No problem.
He won't lie on this. Nah. If he says he's not having, he's not having.
No, man, I'll give him.
And counsel for the appellant
I'll submit.
to provide copy of the writ appeal and the documents to Mr. Mazumdar, who appears on behalf of the respondents, state respondents. No one appears for the respondent number 1, writ petitioner despite service.
He's not interested.
He is not interested. All right. List on so and so after showing the name of Mr. Mazumdar in the cause list. List on 24th May.
At number 30.
May please your lordship. And on the earlier occasion, my lord, the respondent was directed to the furnished instruction my lord, with regard to the last done pay by the my lord, appellant, and any order, my lord, consequential order that had been passed pursuant to the order of this honorable court.
Yes.
The matter was such, my lord. I was, my lord, promoted from the post of my lord, supervisor assistant to the post of my lord, revenue solicitor after due selection. But one, my lord, Kobita Kailani Borua, her candidature was rejected on the ground that she doesn't possess the required qualification. She, having approached this court after evaluating my lord, provisions of the acts and rules, has found that both the petitioner as well as my lord, Kailani Borua are qualified.
Okay.
And therefore, my lord, set aside the appointment. But considering my
appointment of the appellant,
my promotion order.
Okay.
But consequently, this court has held, court has also considered, because I was to retire on 30/4/2022, the court has left to the domain of the state government to utilize my service or to continue my service as the revenue solicitor till the new selection is made.
On contractual basis or a fixed pay basis. After retirement, how can it be?
No, I was to retire on 34. The judgment was passed in March, my lord.
All right.
Lordship, my lord.
Judgment was passed on 2nd November.
No, my lord, that is the 25/3/2022. I was to retire on my lord 34/2022.
All right.
So state government, my lord, did not touch my promotion. They have, my lord, continued my service. My lord, no consequential order was passed pursuant to the, my lord, the High Court's order. And eventually I retired, my lord, on 30/4/2022. Till then, no one was appointed. Now, my lord, in the month of my lord, June, I have submitted my representation for payment of the pensionary benefits, while other my lord, dues have been paid. With regard to the, my lord, the pension, a monthly pension, the deputy commissioner has forwarded with the, my lord, list of the last drawn pay by me. But the state government at that stage, my lord, on 30/6/2022, they have, my lord, reduced that price to the, my lord, supervisory assistant.
Obviously, so you were holding the post without being entitled as such. How could you get the pension thereof?
Now, my lord, that was challenged before this honorable, that order
Yes.
of, my lord, reduction has been challenged before this court. My lord, this court has, my lord, said that my promotion was not on the, my substantive post was the supervisory assistant.
Yes, precisely. You were just as an interim arrangement, you were allowed to work.
Lordship, my lord.
So how could you have been given the pension of the higher post when you were not, as a matter of fact, legally entitled there? And there was a declaration of this court
Lordship.
that you will be working on the post of revenue solicitor only.
Lordship.
Then
Now,
how
my
can
lord,
you
the
claim
rule-
pension of that?
Rule so far is concerned, my lord.
Yes.
It even, my lord, gives the right to receive the pension, my lord, at the last, my lord, salary drawn, last emolument.
Even if it is
drawn.
illegally given.
Well, there's no illegality as such, my lord. The,
It
though
was
court-
an illegality. Once this court gave a declaration that you will not be able to, you were wrongly given promotion. You were just given a dignified position till your retirement. That's what the Constitution Court gave you. That rather than demoting you, let you retire gracefully from the promoted post. But you couldn't expect the financial benefits of that.
No, my lord,
That order was not challenged any further.
my
That
lord,
order passed in the writ petition of Kalyani Barua was not challenged any further.
no, no, my lord. That-
So then-
the initial order was the first.
Now, what is the effect of that declaration?
My lord,
That
my lord, the consequential order was left to the, my lord, the consequence.
where is the order? Where is the order in the Kalyani Barua's case?
Lordship, my lord, that is starts at page 50. Lordship may come to directly page 69. Page 69, paragraph 24. Does the
What was left to the comment? Let us see. Page 69.
that part is at, my lord, page 71. The final part, my lord. For the interim period till the incumbent is selected and appointed with timelines as indicated here before, it would be permissible for the Deputy Commissioner Nagaon to continue with the present arrangement with the respondent number 5, continuing as revenue solicitor in his establishment.
So that's simply an arrangement that you were allowed to hold the post till a regularly selected candidate was appointed. But that doesn't mean that you became entitled to the salary of the post, as your appointment as such was cost. So it was just an arrangement, hence looking to the fact that you were to retire. So that is a graceful exit you've been given, nothing beyond that.
That is one way, my lord, but.
And nothing is left to
my
the,
lord, in
nothing is left to the discretion of the government. Read for your services.
Lordship.
Where is the order to that effect? What you are arguing is
Lordship.
that the things were left to the government
Yes.
to decide.
Lordship.
Where is that direction?
My lord, they did not pass any order, my lord.
They were not required to.
Yes,
This
ma'am.
court has made the
They have
declaration.
passed on 30/6/2022 after my 2 months, my lord, subsequent to my retirement, they have passed that order.
Yes.
And my lord, interpreting, my lord, these provisions of the, my lord, rules, and also, my lord, one of the notification I have, my lord, placed on record, my lord. This court has said, my lord, if the salary is been, my lord, drawn, my lord, as per the regular ROP, and my lord, my lord, the post is in a permanent establishment, as was, my lord, laid down in, my lord, provided in section rule 36 of the pension rule.
Yes.
My lord, in that case also, my lord, the pension is admissible. In that particular case.
Sir,
my
you
lord,
were wrongly given benefit of the higher post salary on the date of your retirement. Right. Even if we consider the case of Rafiq Masih, the recovery may not be permissible, but you can't claim the perennial benefits of wrong conferment of pay scale. How can you claim that?
My lord, even if this particular interim period is taken to be, my lord, a temporary, then also under the rules.
It was not a temporary, it was simply an arrangement, we'll say. We'll term it as a graceful exit route provided to you. That all right, you retire while being designated as on the higher post instead of reverting you. That's what it is, nothing beyond that.
No, my lord, see, my lord, if the state government would have passed an order, my lord,
State government was not required to, sir. Read the court's direction, please.
Because, my lord, the entire judgment, the court has.
Sir, read the declaration, please.
My lord,
Read 24A, page 69.
24A.
Yes.
Yes, my lord. That's
Your
what-
appointment
Sir, sir.
on promotion is cost.
Cost.
That has an absolute effect.
Lord, my lord.
So if you have been given illegally, is given the salary. If you have been given the salary of the higher post
But
or
I'm
pay
not-
scale.
I'm not on the regular part, my lord. The moment that has been set aside, my lord, that.
So
my lord, that's
assuming
gone.
that the state doesn't pass an order, would
My
it
lord, the
mean?
second aspect is that my service was temporary. My service was temporary or whatever, but then I have relied. My lord, I have allowed to retire, my lord, on
Sir, as
superannuation.
an arrangement, not as a matter of right to hold the post. It's just an arrangement, sorry.
My lord, even the rule provides, my lord, even if it is for temporary, my lord, if the. my lord,
It was not temporary, sir. It was an arrangement made by the court. And you were not aggrieved of that order. You could have challenged it saying that since I have been allowed to work, it should be treated to be a temporary appointment. Can't be there.
Only one thing, my lord, one of the order passed by the Honorable Court on the earlier occasion with regard to my reference to the rules, my lord, they are the appointment in.
Let us see which order you are referring.
My lord, there, my lord, the appointment was to a commission. And for a my lord, contractual period for a particular, up to a particular. date.
Language Commission.
Language commission.
Yes, we
Exactly.
have seen that judgment. Yes.
My lord. And there, my lord, she was allowed to, my lord,
Yes.
retire, my lord, as per the, my lord, regular scale of pay and, my lord.
We have even relied upon that judgment, sir.
Lord, my lord. So in that view, my lord, one thing is that it is not a case that, my lord, I was unqualified or there's something on my part that, my lord.
Immediately,
the
you were
appointment
wrongly
was
given
secured
selection by
me.
ignoring the right of another person.
Lord, my lord.
So that selection was caused. Your promotion went with the direction of this court. You could not lay any claim to the pay scale of the promotional post. There cannot be any judgment to the contrary. That was a case of regularization or treating the person to be in regular service, the person who was appointed on commission basis, right?
No, my lord, in the commission, he was
In
appointed
the commission
for a fixed
on a
period.
fixed pay.
Fixed
So
period.
we were called upon to decide the case wherein the services were on commission basis. So same controversy was there.
Commission was not there, my lord. It was contractual period.
We know, sir. That was
regular
Assam
pay
Language
scale.
Commission.
Assam Language Commission.
That was judgment by Honorable Justice Rishikesh Roy.
Lordship. My lord.
Yes.
Lordship, my
We
lord.
know.
Now here the other aspect, what is there, my lord?
Yes.
The last drawn pay or the 10 months, my lord, average pay, my lord. Even if it is, my lord, taken, my lord, the 25(3) is to be, my lord, from that day onwards, I did not have the, my lord, regular service, so I am not entitled. Then also, my lord, the 10 months, my lord, emolument, average emolument has to be taken into consideration for payment of the pension, my lord. But that has not been taken, my lord. Straightway, my lord, I have been relegated to the post, my lord, where I was, as if, my lord, at the very beginning, my lord, my appointment was illegal. But this setting aside,
10
even if it
months
is.
pay on the promotional post till you retired, you continue to get that post pay or not?
Yes, I paid.
So, all right, feel happy with that. They are not affecting any recovery.
No, my lord, the two things, my lord. One is the last drawn pay, the pension, or secondly, my lord, the average 10 months of the last payment made. Now, at least that has to be, my lord, taken into consideration. My
It
lord,
was on the promotional post or not?
it was yes,
That was for the promotional post.
promotional.
It has been declared to be illegal, so that gets swiped off.
Now, that will be effective from 25(3). On
Yes.
the date this court has set aside the order. My lord,
Your
it will not
promotion,
go-
if it is illegal from the day you are promoted. It can't relate back to any other day or relate forward to any other day.
My lord,
It has been struck down at the root. Because the case of another person who was actually entitled was ignored wrongly.
no, that has not, they are entitled is that was not decided. My lord. It was not decided whether she is entitled. Only thing because it was a wrong, my lord, decision of the government that her qualification was not accepted to be, my lord, eligible. Otherwise, my lord, I am also
The
qualified.
issue
She is also
is
qualified.
your promotion has been cost. It's a fact. Right. So what is the effect thereof? You can argue on that. That whatever emoluments you drew on that post,
Yes.
the order could not have a retrospective effect. Argue on that.
Yes, madam, that is one of the, my lord.
Let us see. Let us see the order. Then again. Where is that rule you are referring to last 10 months?
My lord, the affidavit, one my additional document I have submitted with the notification, my lord. That the part of the record, my lord, it was filed on 10/2/2023. Well, I'm referring to clause 4, my lord. If you look, got it, my lord, page 91 serial. Full superannuation pension shall be determined at the rate of 50% of last month's emolument drawn or 50% of last 10 months average emolument, whichever is beneficial to the employee.
So in the gradation list, the red petitioner Kalyani Burwa was senior to you.
My lord,
In the gradation list, Kalyani Burwa was senior to you.
senior to me.
And
Seniority is not the, my lord, criteria. This is the, my lord, the minimum length of service, my lord. That is there.
so
So
she
therefore,
had a minimum length of service also.
Yes, she had minimum length of service. I had, my lord, minimum length of service. There are some other candidates also had the my lord, disqualification. So
But she was disqualified on account of educational qualification.
Yes.
Or not considered.
my lord, the education qualification had been adjusted as not eligible. My lord. But the rule says, my lord, it should have been she was eligible.
Yes.
So my lord, till my lord, the date of my lord, setting aside, my lord, I have my lord, worked, my lord, and this observation is also there that both the persons are my lord, qualified. My lord, had this my lord, the subsequent my lord,
Even the pensioner was illegally appointed. Maybe the promotion was another person. Right? 10 months average.
Read the rule, please. 10 months average, you are saying. Where is it?
my lord, the affidavit, my lord,
Annexure C, page?
page 91,
Yes.
serial number 4, my lord,
Yes, yes.
superannuation pension.
Yes, what do you say to this, madam? Yes. What do you say to this?
Chip, the first thing which I would like to say is that judgment and order dated 25/3/2022, which is the in WPC number 1153/21. That is where Kalyani Barua
Yes,
basically
yes.
this thing was allowed by law and their promotion order was set aside. That has not been challenged.
Maybe,
as on date.
maybe. It was not the fault of the employee
And
that
my lord,
that he was promoted.
my lord.
It was not his fault. Fault lay at the end of your authorities. Is it correct? He did not make any misrepresentation. So whether this order would have a retrospective effect, whether it would wipe off the services rendered by the employee on the promotional post prior to the passing of the order.
And my lord, moreover, according to section 31 of the conditions of qualifying service, that is as per the Assam Service Pension Manual, there, my lord, the service of an officer for qualifying for pension, it has to, my lord, the second criteria that the employment must be sustained and permanent. Here, my lord, because the promotion order of
It was a substantive appointment as per you.
But
What
my
would
lord-
be the date of effective date of his reversion to the post? That would be the date of this court's order.
My lord.
Before that, there was no such declaration. And when did you issue the order? Read this, OM is reading. What is your response to this? Clause 4. Why the case of the employee is not to be considered in light of this clause? Examine it. Pass a reasoned order. What is the date, what is the order you have passed pursuant to the judgment in Kalani Barwa? Where is that
Your
order?
Lordship, I have in my 36/2022, Your Lordship.
Where is that order?
That order is
36.
36, Your Lordship. It's in the writ appeal, Your Lordship. I mean, it's in the affidavit in opposition which I filed at page 102, Your Lordship.
102.
It is at page 70 of the repetition.
Page 70 of the writ petition. Writ appeal. Lordship, 102, annexure 1 of the affidavit of opposition. With reference to the letter on the subject, sir, and in the response of the order of the Honorable Guwahati High Court dated 25/3/22 in WPC so and so, I'm directed to request you to kindly make necessary arrangement to allow the pensionary benefits in respect of Sri Krishna Dev.
Does it take into account that OM you have issued, sir? Salary drawn for last 10 months. Assuming that he is not entitled to the last pay drawn on account of the fact that he was just on a working arrangement. But what about this clause 4 of the OM?
The issue is from 10 months from when, madam? That is from
10 months from the date he retired.
my lord.
Average
34.
is average, sir.
Yes, sir.
So
36.
you make a representation in this light. We'll keep your appeal pending and direct them to decide it by a speaking order. And counsel for the appellant has drawn the court's attention to the office memorandum dated 12 July 2017 within bracket annexure C issued by the Pension and Public Grievances Department, Government of Assam. Don't need to write annexure, and urges that even if the last pay drawn by the last month's emolument drawn by the appellant is considered to be for the post of revenue registrar, but as the appellant had worked on the post of as a supervisor assistant, but since the appellant without any fault of his had been promoted to and had performed duties as a revenue registrar for the previous last 10 months before his retirement, he is entitled to have his case considered for pension under clause 4A of the aforesaid memorandum. Then Government Council candidly concedes that while calculating the pensionary benefits of the appellant, the effect of this office memorandum seems to have escaped consideration of the authorities. In this view of the matter, the appellant is given liberty to file a detailed representation to the Pension and Public Grievances Department within next 15 days, along with a copy of this order. Upon receiving such representation, the same shall be objectively considered and decided by a reasoned order within a period of 30 days thereof. The writ appeal shall be listed after 2 months, after 8 weeks.
Obliged.
They are only seeking pension. They say that assuming as an
Letter number 32 of supplementary list.
mistake on part of the authority in undertaking the normal processes. There is no dispute regarding the qualifications or the eligibility of this. So it was an error of them that he was promoted. That was given. They had to conduct the pension. Assuming in the pension size he didn't get. Since he has retired in the meantime, that is why the last 10 months, the OM that OM is very clear that either the last pay or the last 10 months. That is only part. pension will not be met. Employee pension in accordance with this point, with the LPC. Otherwise, this party is not agreeing because he is superintendent.
Yes. Milord, this matter is supposed to argue by J. Roy's senior counsel. His health condition is not fine, Milord.
Who?
J.
Mr.
Roy.
J. Roy.
J. Roy.
It is stated that argument counsel, Mr. J. Roy is not well and a request is made to adjourn. Which is this matter? The case for today. List after 4 weeks has played.
The number 33.
Made to the lodge. My lord, the petitioner respondent, my lord. My lord, she was working, a work lady, she worked in a particular Apollo hospital in Guwahati, my lord. The charge was brought against her, or my lord, sending, intimidating and threatening MMS to the, my lord, senior executive of the hospital. Now, earlier also, my lord, she was guilty of a similar misconduct. But on an earlier occasion, my lord, taking her apology, my lord, she was let off. Subsequently, in the year 2017 and 18, she again resorted to the same practice, my lord. For a result, my lord, a domestic inquiry was conducted. In the domestic inquiry, she was found to be guilty, my lord. As a result, there was a reference, my lord. And of course, in the inquiry, my lord, she was ordered to be terminated from service. Then, my lord, reference was there. The industrial tribunal, my lord, ruled in her favor. Against that, we approached this single judge. Single judge also dismissed our writ petition.
Right.
Now, say the only ground on which single judge interfered with the matter, if a lordship will kindly come to page 20, only one paragraph, my lord.
Right.
Correct.
Yes.
As noted above, during the course of proceeding before the labor court, management has kept a stand that they are not relying upon the inquiry report. Accordingly, the management had led additional evidence and examined 2 witnesses to establish.
So
the
what was the
allegations-
reason for you not to rely upon the inquiry report?
My lord,
What was the reason for the management not to rely upon the inquiry report of the inquiry conducted by your own team?
my lord,
Then
it is there, my lord. No, my lord, even then Supreme Court says, my lord, even then independent.
was there a vision in place?
Looks like.
Then
No, my lord, what I'm on, my lord,
Yes.
the lordship will kindly appreciate. Merely because, my lord, the MMS were not supported by an
You-
65B
two
certificate.
things. Firstly, you disown your own inquiry report. And secondly, you are not able to produce substantive evidence to support this.
That is where I am on, my
Yes.
lord. If your lordship would kindly permit me to place 2 pages, my lord. If your lordship would first come to page 108.
Yes.
This is the evidence in chief of my lord, management witness number 1, para 4,
Page?
page 108.
Yes.
Yes. And I'll refer to the cross-examination of the work lady also.
108 is
108, my lord, it's a part of the examination in chief on affidavit of
on
the management
affidavit.
witness.
All
one.
right.
Para 4. That the management begs to submit that the workman was rightly terminated from her service after giving opportunity to be cautious in future for her previous conduct towards the discipline of the management by wearing doctor's apron, and even after repeated objection and while in caution period, the workman Srimati so-and-so repeatedly sending intimidating and threatening voice messages and pictures to HR head Sri so-and-so in the month of December 2017 and 18 to WhatsApp. Now, exhibit 3 was that, my lord. Then if your lordship should kindly come to page 120. This is the management witness number 2. Page 120, para 4 and 5.
Whether these messages were proved as per law.
No, my lord, but there my submission would be, my lord. My lord, the Evidence Act, will it apply with all its rigor in its application?
Question of sanctity of these electronic messages.
Yes. No, my
When
lord,
now we are
what
in the
happens- what
age,
happens, there is admission of-
everything can be
No, what happens
fixed.
what happens when there is an admission, my lord? Please come to page 137.
Yes.
That's the cross-examination of the work lady. I was initially appointed as a ward girl in the International Apollo Hospital in the year 99. My termination was done in the year 2018, and as such, I was in service for more than 19 years in that hospital. And as a senior employee, I have some knowledge about administrative rules and regulations of that organization. Sometimes I used to assist the employee as spokesperson for them. During inquiry, I filed an application for engaging an advocate for my defense. There was a first incident and that was inquired, and ultimately I was advised to be cautious in my conduct in future. Exhibit 5 was sent by me as a voice message. The message was sent to HR so-and-so. I did not submit any written representation containing grievance. Exhibit 10 was received by me where it is stated that may take a help of co-worker for my assault, but I did not do that and decided to take legal assistance, but I was denied legal assistance for that. I did not participate in that is line, my lord. I send the voice message for and on behalf of the workers. There is an admission, my lord.
Yes. What is the message?
Now, my lord,
What is the message?
My humble submission is, my lord, the purpose of introduction of section 75B a criminal trial, we could appreciate.
Not a criminal trial. It is general principle of admissibility. It is IPC. Evidence Act doesn't make difference between a criminal trial, a civil trial, any other proceeding.
Preponderance of judicial view on, my lord, application of Evidence Act to the proceeding domestic inquiry, my lord, has been by and large, my lord, now it is well settled. Yes, the principles will apply, my lord. The spirit
What
will
is
apply.
what is the cross-examination from S. Roy? Let us see.
Yes, Hetu Court.
Where is that?
Page number 139, my lord. The management did not issue copy of the exhibit to the employee. No copy of preliminary inquiry was issued this month.
All right. Where is your inquiry report? Let us see that.
Yes. Inquiry report to condition 9. Page number? Page 62, my lord. If your lordship would kindly come to page 64.
Why these underlined and whitener marked pages all everywhere?
And page 66, my lord.
Yes.
At the heading is admission of charge.
66. Yes.
Charge employee during inquiry present in person on 19/5/18 before the inquiry officer vehemently and adamantly admitted the fact of reply of the charge officer on given fair hearing and repeatedly asked to state her defense and also to submit her written statement and witness in the proceedings for getting clarification against the charge and evidence of voice recorded in the CD in the nature. As produced by management, but the delinquent was stubborn and vehemently replied that she had brought an advocate to defend her case.
So she was opposing this CD tooth and nail, and you did not prove it. What else was to be done?
No, my lord. Therefore,
Sir, she was not required to cross-examine. Even if she admitted, you did not prove what her admission would do.
No,
Because
I was only
unless she says that I sent a voice message.
I appreciate.
What is the voice message? We don't know because it was not proved.
My lord, all that I am trying to submit for a lordship's kind consideration is, my lord. It's a question of discipline in
It's a
an
question
organization.
of a highly professional hospital which just fleeces the patients like anything at very difficult times even. They don't bother about human life, dignity. And if they are now put to test in these proceedings, they say that you please follow the law. What happens when a patient's body is lying, whose relatives are not able to make the payment? They demand.
Correct.
So do these people deserve this kind of indulgence? Engage proper inquiry officers.
My only submission
They
was,
were very
indiscipline. And she was,
she was trying to espouse the cause of her peers. That's what it seems.
She's a work lady, my lord. She's in the habit of wearing apron, though she's not a doctor. Then, my lord, she's indulging in, my lord, a lot of indiscipline.
Hold a proper inquiry. Act professionally as you do while dealing with the patients.
True, my lord. it could have been done in a much better way.
Yes.
No, I was only thinking if a lordship would kindly examine one aspect, my lord,
Yes.
regarding the application of Evidence Act to the
Why
disciplinary
should it
proceeding.
be?
my lord.
Why, how have you proved the message? Has anyone spoken out what is the transcript? You presented a CD. What does it contain? Now answer it, please.
I leave it to it.
Do you want a dismissal with cost? Fighting with a low paid employee. Supreme Court precedents are there now. All right. All right. Rejected.
Deeply.
My lord, I'm appealing for the work.
Yes. We'll mark your presence, sir. Don't worry.
The number 34. On last occasion, I was directly to produce the provisions of diluted text of Tamil Nadu law. Same provision,
Proceedings of?
Tamil Nadu diluted text, section 1911.
The VAT Act. Okay.
Yes, sir.
What is the issue involved?
So they challenge here, section 16(4) of the CGST Act law.
On the ground?
The ground that it is infringement of their fundamental rights.
What does the provision lay down?
16(4)
Yes.
CGST. For a registered person shall not be entitled to take input tax credit in respect of any invoice or debit note for supply of goods or service or both after the due date of furnishing the return. Under
Delay on the
Yes.
issue of delay.
Main ground is delay.
Yes.
And here also Lordship,
You are referring to Tamil Nadu VAT Act.
that was-
Whether there is any judgment on this?
yes,
Act. Which judgment?
2019, 13 SCC page 225.
Which is the provision you are referring to?
Lordship here, section 11, 1911 Lordship. In the
1911.
Tamil Nadu VAT Act.
Just hold on, please.
I have a judgment.
19.
Yes, 1911.
Tamil Nadu VAT Act.
Yes, Lord. That was challenge.
Where is 1911? Okay.
But I can give the copy of the.
Yes, yes, just hold. ITC.
Yes, 11 says, in case any registered dealer fails to claim input tax credit in respect of any transaction of taxable purchase in any month.
Before end of financial year.
19 Lord. 11.
Yes. What is the opening lines?
Lordship, in case any registered dealer, 11 Lord.
No. What is the restriction?
Lord, restriction Lordship, any transaction taxable purchase in any month, he shall take claim before the end of the financial year or before 90 days from the date of purchase, whichever is later. So here also limitation has been put, Lord.
There is a limitation for laying the claim.
Yes, Lord.
Yes, yes.
And the present act, CGST Act also claim,
This is the same.
almost same.
Where is the provision quoted?
16(4) Lord. CGST Act Lord.
Let's see. Is it quoted anywhere? GST.
Yes, Lord.
It's there on page 11.
Page 11 Lord. A registered person shall not be entitled to take input credit, tax credit in respect of any invoice or debit note for supply of goods or services or both after due date of furnishing of the return under section 39(9) for the month of September following the end of financial year to which such invoice or invoices relating to such debit note pertains to furnishing of the relevant annual return whichever is earlier. And this was challenged before the Supreme Court in 2019, Lordship, paragraph 36 of
Yes,
the judgment, Lordship.
Not this 1911.
What do you say, sir? Yes.
Well, first of all, you also find as per section 16.1 and 16.2. I'm entitled to the input tax credit. Now,
Question is of limitation.
my lord,
Yes.
now 16.4 only says, my lord, that the return, if it is due date of return, if before that it is not claimed, then you are not entitled to. Now, as you also be aware, my lord, that similar matter came up before in the case of insolvency matter, my lord, the 330 days, it has to be completed mandatorily. The apex court said, my lord, that mandatory work cannot be used because for various reasons, it may not be filed. Completed.
Sure, sir.
So-
Here is a very limited scope. Mr. KL has cited a judgment
Well,
on a perimeter statute.
Well, I will submit, my lord. First, that similar petitions are pending before the Itanagar bench of the Guwahati High Court.
How does it make a difference? That those petitions will be governed by this judgment.
Well, I will show to you.
Then you will have the opportunity of carrying the matters to
No.
Supreme Court.
Well, let me,
Yes,
I am trying to, my lord, place whatever is there with me, my lord.
yes, definitely.
Thereafter, your worship will certainly take the decision. It can give it. It's एक मिनट में निकलना सुबह एक मिनट शर्मा को दस
Number 5.
अभी तो कब तक
Yeah, I will talk. ठीक है.
Well, your worship, I will place one judgment, my lord. Look,
Judgment on what
on the
issue?
Supreme Court, my lord, on the admissibility of the writ petition.
That's maybe this judgment doesn't indicate anywhere that there was an identical judgment of Supreme Court.
You lost me, can you see, my lord, the reason?
Yes.
I will just tell you, my lord. This is heard the so and so. After going through the.
So we'll call that, give us the number. We'll call it day after tomorrow, here only.
Well, secondly, my lord, this is, my lord.
Why do you worry about that? We'll hear both the petitions together.
I found, my lord, I'm placing before.
Sir, this is the thing, you are trying to hold on to strings. There's nothing substantive in this argument.
Secondly, my lord, secondly,
Yes.
please. In the judgment of the apex court,
Yes.
the section 1911, your worship, may I see? It says, my lord, or 90 days thereafter.
Not thereafter,
Your worship, see?
before,
My lord, my lord.
end of the financial year or before 90 days from the date of purchase, whichever is later.
From the fails to comply, claimed input tax.
Claim.
In respect of a transaction taxable so and so in month, he shall make the claim before the end of the financial or before expiring in the 90 days from the date of purchase, whichever is later.
Yes.
So, my lord,
So the bigger window is given
in this
to the
1911,
dealer.
1911, the window is given, and you'll also see that GST Act came into force with effect from 1st July 2017. Now, at that time, the technical glitches and all the difficulties were there. Because of that, my lord, the persons were not being able to upload. There were several petitions, several judgments were there, not that all those things were there.
It's not a case of you not being able to apply because of some technical glitch.
My lord,
It's not the case.
my lord, I'm telling you, lord. I've said that because of technical glitches.
What glitches? Demonstrate, please.
My lord,
You are in a
my
writ.
lord, everywhere that it was not been uploaded, it could not be uploaded.
Particular case,
Now-
what instances have you cited?
No, no.
What are the attempts made by you
My lord, I will submit, my lord.
to lay the claim?
I'm just,
Please state the date.
my lord, I will submit.
Not like a blanket argument. There were technical glitches. That can't be there.
The question which is there,
Yes.
in this case, 16.1 and 16.2, and 16.4 is not overriding. 16.4, you also may see.
Yes, please.
16.1 is the overriding effect, notwithstanding anything contained. 16.2, you also may see. Notwithstanding any contained in this section, no registered person shall be entitled to credit in respect of the supply of goods and services of both unless these conditions are fulfilled. Now, 4, you also may see.
Shall not be. There is a not
Certainly, my lord.
non-obstante clause.
A registered person shall not be entitled
In
to.
absolute terms, it is
My
there.
lord, you also may see, my lord, if 1 and 2, my lord, 1 is fulfilled, 1 is says, my lord, every registered person shall subject to the conditions and restrictions as may prescribe and in manner specified in section 49 be entitled to take credit of the input tax credit so and so. Now, this one, 4 is not subject to someone, my lord. 1 is says that I am entitled to.
Yes,
Now,
that
4
is,
my lord,
1 and 2 are for establishing your entitlement.
my lord, 4 only says.
4 is the procedure for laying the claim within a stipulated period.
Absolutely. Now, the question is that what is the substantive provision and what is the procedural? Now, the procedural provision, the lordship may kindly see, my lord, if the procedural provision takes away the substantive right, then the apex court said, my lord, that this law has to be examined both from the angle of the procedural as well as the substantive provision. ये कौन सा मिल रहा है? गणपति, ये।
Yes.
Para 49 below.
Nine. We are dealing with a taxing statute. There has to be a strict interpretation, settled law.
But
this is not in relation to a taxing.
Madam, you lost me. Can you see page, my lord? I may just read page 52, para 52.
Yes, please. Yes.
My lord, the courts are empowered to test both the procedure as well as the substantive nature of these instruments in the constitutional challenge.
Yes.
Thereafter, your lordship, the test should be based on combined reading of Article 14, 19, 21 of the Constitution. One of the offset of the test in the part 3 of the Constitution is the development of the doctrine of manifest arbitrariness.
Yes.
A doctrinal study of the development of this area may not be warranted. It is well said, noted so and so. We may state that development of jurisprudence has come full circle from an entire overly formalistic test of the classification to include the test of manifest arbitrariness. A broad formulation of the test was noted in so and so. Now, in this case, my submission for lordship is that this provision of section 16(4), normally, my lord, we will look into the constitutional validity, we look at the legislative competence and all those things only. This concept of manifest arbitrariness was not there. So this concept, and this has come, my lord, in the year 2023 judgment.
22.
22.
Is printed later. Judgment is of office.
So my submission before lordship that, my lord, that when the constitutional validity is challenged and the certain points are raised, so this is not a case to be dismissed at the threshold of the preliminary stage. You will also will examine it, my lord, generally, and the constitutional and similar matters are pending in the Bombay High Court. Notice has been issued on the 64th.
Mr. Kale, let there be an academic debate. There is no problem as such.
At least, my lord, you also will examine it, my lord, from the angle thereafter, my lord.
Let's examine. Let the other high courts take a call. Otherwise, the case is open and shut.
Yes,
we can decide it right now.
Nowadays, no case is open shut because nowadays,
that's true. There you are too.
Every day,
there is nothing certain under this
system. I find that the judgments are new.
All right.
Something are coming.
Another has been previous matter where the input tax credit has been discussed. That is also reported in the same volume. So this issue has already been taken care
No
of.
issue is similar. One word makes a difference. And
let's keep the academic debate open. What is wrong?
Sometimes the academic debate also, maybe that when the matter comes up like that.
Yes, by the time it comes up, maybe some new development may have taken place.
Maybe that I can be able to show your lordship the direct judgment that the Supreme Court has come on the interpretation of the same. Nobody can.
We'll record in a small order of admission, but of course, no interim relief.
I'm applying, no? Not sure.
Admit, the scale wave service is permitted to file affidavit in a position within next 6 weeks.
Well, your lordship may not observe that no interim order, only notice order.
You withdraw the prayer?
Well, the prayer is there when I'm at present insisting
no,
on that.
Then we'll have to decide.
When I'm not making the prayer,
he is not pressing. Mr. Saraf,
that may also only admit and will that.
No, otherwise, you may use the factum of admission in another way.
No, admission.
We'll have to decide on that.
Well, interim prayer at this stage, at present.
Interim, in view of the fact that, in view of considering the judgment relied upon by Mr. Kale in the case of so and so, at present, the prayer for interim relief is not being considered.
I have applied to.
Matter number 3 and 4 passed over matter.
Your lordship. My lordship, in item number 4, my lordship, the petitioner has been already retired, so that may be closed.
Number 4, contempt.
Yes, madam.
Then counsel, you are Mr. Laskar,
Yes, madam.
submit that as the petitioner has superannuated in the intervening period, comma, he is not desirous of continuing with this contempt case. Hence, the contempt proceedings are closed. What about 3?
My lord, in see, my lord, affidavit in opposition has been filed, my lord.
So,
in that affidavit in opposition, my lord, we have claimed, my lordship, minimum pay scale. As per order of the Honorable High Court in page, my lordship.
yes. And they say that they have already done that. There is a notification which was referred to.
Yes, my lord.
Ms. Nayak was appearing, no? First round.
My lord, he is on legs in another court. My
There is a notification. If you are now aggrieved by that notification, you have to challenge it as per law. What is the contempt?
Yes, ma'am.
In the state government has filed an affidavit in opposition, annexing therewith the copies of the notification dated 8th March 2019, further amended by notification dated 3rd October 2019. First of it has been indicated that the petitioner is being extended the benefits of minimum pay scale in terms of this court's direction. In this background, apparently the respondents are no longer in contempt of this court's order. If at all the petitioner is aggrieved of these notifications, he has to take recourse of the suitable remedy for challenging the same. The contempt proceedings are closed. Rule is discharged.
Deeply obliged.
Matter number 6.
I'm sorry, my lord, when the matter was called up for the first time, I just failed to appear. My lord,
Yes.
here the problem is of twofold, my lord. First, in hot haste, they have issued the pay slip to show that they have done something. But most of the pay slips, there are errors, my lord.
Defects.
Like defects, like my lord, someone is getting ACP, his ACP pay has not been shown. Then, my lord, house rent allowance, previous, it has been shown in the previous.
What
pay
you
slip.
do is
Now, they'll have to correct it. There is no doubt.
you appoint one of your officers to be the nominee, nodal officer kind of thing. Let him sit with the
But they
authorities.
have initiated, they have given us an email ID, likewise the previous one, my lord. Our officers, my lord, send their objections in the email ID. That also not responded.
What we'll do is we'll ask the law remembrance to take up the matter with the government. To have it rectified.
That will be proper. And
Yes.
another aspect is that they were supposed to come up with a robust mechanism, like a
Yes.
portal, which will be integrated to the AG.
That you have stated in paragraph C from the affidavit filed on last occasion. Lord.
That has to come up to a reality, my lord.
Yes.
So in
Can't
that
be
way-
just an eyewash kind of thing.
No, lordship, we are taking it
They'll have to
seriously,
install that, then, my lord, it has to be tested.
Tested whether it is
4-5
working properly.
months, then only-
Functionality has to be tested. Yes.
So far as the pay slips are concerned, that are sent through email.
But he says that there are
That may be
errors.
Which can be sorted out, lordship, that can be
If
sorted
you
out.
don't have, then one time you say that's a robust system. If there's a robust system, where's the scope for errors?
Lordship. Though so
Need
far
to
as
work on that.
No, so far as that system is concerned, lordship, that the discussion is going on with the state authority and the agency, private agency, to whom the work has been assigned. It will take some time, lordship.
If you point out the particular instances,
Yes, lordship,
then
let
we'll
them
ask
point out,
the
lordship.
law secretary, law remembrance to take up the matter with the state authorities.
Lordship.
Right? Okay. The Learned Government Council, Mr. Chakravarti submits that the online portal has already been put in place. However,
My lord, subject to online portal has not.
has not been.
No,
No, lordship.
They are
we
doing
send-
only
we
through
are send-
email.
We are
The
sending through email.
pay slips
We have installed GEM, lordship. GEM is in software, lordship. Through that.
and
we
a
have
software has
used-
been put in place for providing the pay slips to all the officers of the petitioner association by the online mode. However, Learned Council, Mr. thus submits that it would be better if a proper online portal is put in place so that the human intervention in the matter of generation of payslips can be eliminated. We hereby direct the law remembrancer to coordinate with the authorities of the Office of the Accountant General to ensure that a proper online portal is put in place so that all the task of generating the pay slips can be made paperless and the human intervention in this process can be eliminated so as to reduce the possibility of errors and to expedite the process.
My lord.
The requisite exercise in this regard shall be completed within the next 4 weeks. List thereafter.
My lord, will you kindly, a date may be.
List on 21st June.
My lord, deeply obliged.
Number 9. May I please your lordship? My lord, I apologize for the inconvenience, my lord, earlier occasions, my lord, my lord, that my prayer here is just, my lord, I am appealing for a caveator, my lord, for here, my lord. But my lord, I do not, the petitioner do not want to place the.
And Council Mr. Soncho appearing on caveat submits.
My lord, I do not want to place the caveat, my lord.
You do not want to press.
My lord, petitioner.
Submit that he is not desirous of acting on the caveat. So you're not going to appear.
My lord, actually, I have failed to communicate with her in.
As the respondent number.
Response.
The respondent numbers, private respondent has not given him the instructions to appear in this case. List after 1 week. All right. The caveat is discharged. Okay. Hold on.
Item number 12.
Mr. Chaudhary, we were about to dismiss it for non-prosecution.
Lordship, in fact, the name which appears for the appellant, Lordship, it's not a CGC.
He is not.
It's not a CGC right now. Therefore, I was wondering whether it was a railway case because railway old cases, they are engaging the whole set of advocates.
Okay.
But I checked up the records. It's from the SSB, Lordship. These records are not transmitted to me.
So then what do you want?
I'll call for the records from the
Mr. Arkadev Chaudhary, the PSG puts in appearance on behalf of the appellant. His name shall henceforth be reflected in the call list. He prays for and is granted 4 weeks time to complete his instructions. He shall also apprise the court as to whether the order under challenge in this writ appeal has been, which was passed, order under challenge dated so and so, which is assailed in this writ appeal, has been complied with or not. Employee has passed away. Now his LRs are there. List up 4 weeks. So we'll take it, start at the 2. We'll start with the appeals at 2.
May I please your lordship, my lord, on the last occasion, we left, my lord, on the judgment, my lord, which were all in the negative aspect that has been taken. From the same witnesses, there are certain other positive aspects which are thrown like subsequently, my lord. But right now, my lord, I'd like to say, my lord, that part has been dealt with elaborately, my lord, whether there was any deflection of money, siphoning of money, and then paid to A3, that is Mohit Hussain. Thereafter, it was inwardly remitted to DSD for buying of arms, my lord. That was the original case of the prosecution, my lord. So for that, since as your lordship is well aware, my lord, that evidence of conspiracy cannot be directly, my lord. So it has to come from circumstance of that. Yes, my lord. Inference can be also drawn. That is there, my lord. Without doing anything, also there may be conspiracy, my lord.
Yes.
So in that aspect, my lord, right now I would like to throw lights, my lord, how the learned trial just dealt with that conspiracy aspect, my lord. So I'll be opening on that count, my lord, first. There I go. Yes, two, my lord. My lord, of the judgment, my lord, volume 8, probably page 2009, my lord.
Please refer to the paragraph.
Yes, my lord, I'll referring para 208 and 209, my lord. Eight. This is leading to discovery here, no? Conspiracy? It is one line, sorry. One line, I went wrong. Sorry, I went wrong for the one lanchana part. 120B is page 2144, my lord, para 428, my lord.
Yes.
And actually, it starts, my lord, from page 2141, 422 is the para, my lord. And the finding is recorded on 428, my lord, last para, my lord. So I'd like to take your lordship to para 422, my lord. Here in this case, we have appreciated all the evidence led by the prosecution side in support of the charge so framed with the aid of all the circumstances at our command. We have also considered the defense version and given much needed credence as it deserved. We adopt a realistic approach in the matter of acquisitions of evidence. And in doing so, we have not allowed hyper-technicalities and figment of imagination to override the realistic and genuine approach. We have also kept in mind the observation of the Honorable Supreme Court in British Radha versus State of Maharashtra, my lord. So this relates basically to the circumstantial evidence case, my lord. Then coming on 423, my lord, the main tab. And having considered all the materials particular, we find that the prosecution side has succeeded in bringing home the charge of conspiracy under 120B against all the accused persons beyond all reasonable doubt. It is to be mentioned here that the accused George Lamthanga has turned approver and granted pardon, and accused Samir Ahmed has pleaded guilty and convicted already. The prosecution side has been able to prove beyond all, been able to establish beyond all reasonable doubt that the accused person, namely R.H. Khan, Ridaul Hussain Khan, A4, Corona, all the accused name, the government officials, and the contractor's name, have entered into agreement with the members of some members of the DST to do an illegal act, Here I'll pause for a moment and say, till now the London trial court is not sure who are the members. Some members. If your lordship gets me, some members means vague, Once you write a judgment that is beyond reasonable doubt, it is the person directly connected.
Yes.
Who are those DSD members whom we conspired with? Because the original case of the prosecution was there. I gave the money to Mohit Hozai. Mohit Hozai in turn gave it to DSDJ, Jewel Garlosa, And accordingly, it was converted, rupees was converted into dollar. Then it was sent for buying of arms, abroad. So TSD to do an illegal act, which is not illegal, but legal, means to help them in raising funds. And in order to commit such acts, siphoned of government funds made for development of NCC district and handed over to money to terrorist gang DSDJ through Mohit Hozai to procure arms and ammunition to assist in conducting the terrorist act. The prosecution side has also been able to prove beyond all reasonable doubt that Sri Fozendra Hozai, Babul Campride, and all the accused name has been given by Srimati Molskami Niranjan Hozai, after forming the terrorist gang in 2004, entered into an agreement with Ridaul Hussain Khan, Karuna Soikia, Jayanta, Devashish, and Sandeep Ghosh to do an illegal act, that is to raise the funds for the terrorist gang by siphoning of government funds, converts Indian currency to US dollar to procure arms and ammunition and to wage war and to cause death of innocent person, terrorize people, extort money, disrupts works of gauge conversion and construction of East-West corridor. It is of course true that the prosecution side has failed to establish kidnapping for ransom here in this case. Notwithstanding failing to establish this, the other parts have been proved by the prosecution side beyond any shadow of doubt, and the same unerringly point out the guilt of the accused and accept that no other hypothesis is possible on the facts and circumstances on the record. Accordingly, the accused person is hereby convicted under section 120B IPC. So this is the only finding, my lord, based on that, my lord, which is not based on records, my lord, because there is nothing has been proved that I have siphoned off or misappropriated government funds. Rather, there is a positive evidence on the record that every SNP, that is every schemes, my lord, were executed properly. Everything were done as per financial rule, my lord. So there is not an iota of evidence that any of the contractor gave them, after drawing the money, gave it to the terrorist or gave it to me so that I can give it to the terrorist, my lord. Nothing as such is there, my lord. And for the deflection part is also been well looked after by the CBI case, my lord, which the IO has recommended for registering a misappropriation case, my lord, which has been done, and the trial is on, my lord, as I have been told, my lord. So now another aspect, my lord, with all respect, my lord, if I'll not point it out, probably I'll be failing in discharging my legal duty as well as the senior advocate duty. Here the charges were under 3 heads, my lord, 17, 18 and 120B. The Honorable Trial Court, my lord, while dealing with 18, my lord, section 18, my lord, section 18 says of conspiracy, but has said that it is superfluous. 18 is not required. Rather, it should have been the other way around, because 120B is an IPC meant offenses to clubbed in, my lord. But here the Honorable Trial Judge, my lord, if your lordship will see para 428, my lord, that probably needs to be corrected, my lord. Because special laws, when there is prescription, my lord, that will prevail, my lord. It is not the other way around, my lord. I'll take your lordship to para 428 to 144. Irrespective of my outcome of the judgment, my lord, this legal proposition, probably your lordship will have to give a look into it, my lord. However, on the facts and circumstances, we already find and hold that the conspiracy under 120B stands proof against all the accused person. But on the same facts and circumstances, the offense under 18 of the Unlawful Activities Prevention Act stands made out. Since we have already held the accused guilty of 120B IPC for the charge of conspiracy, we are probably, it should be, I am of the view that their conviction and sentence under 18 of the Unlawful Act Prevention Act is unwarranted. Accordingly, they are acquitted of the same. So this unwarranted, my lord, means unnecessary or superfluous. If your lordship permit me, I can take your lordship to that provision, my lord. Because section 18 is specially prescribed for conspiracy under the special provision, under the special act. Rather, 120B will become redundant, my lord, because of two aspects. Since 18 is dealing with it, and your lordship is well versed, my lord, under the NDPS Act, section 29 is there, my lord, to look into. So you need not take the aid of 120B. And 120B will come into play, my lord, where there is a penal offense.
Yes.
And in a Supreme Court judgment, if a lordship feels I should address, my lord, this point, in a Supreme Court, a similar situation arose regarding interpretation of 38 and 39 of the Unlawful Activities Act, my lord, judgment. Judgment get a But can I hand it over, please?
Yes.
No, it's not a Dada. Oh, Dada, I didn't that happen. My lord, before that, my lord, I'd like to just lead your lordship to the head notes, my lord. Section 17 is the section dealing with punishment for raising of funds for terrorist act. Section 18, punishment for conspiracy, etc. And as your lordship know, 120B is for punishment for criminal conspiracy. Now the trial court has said that 18 is superfluous in view of section 120B, which according to me will not be a correct proposition, my lord. So I'm reading 18, my lord. Punishment for conspiracy, etc. Whoever conspires or attempts to commit or advocates, abets, advise, incite, directs, or knowingly facilitates the commission of a terrorist act or any act preparatory to the commission of a terrorist act shall be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and shall also liable to be fined. So this is a special provision, specially dealing with such type of acts, my lord. So then, my lord, the honorable.
This is a punishment for conspiracy in relation to terrorist act, not for terror funding.
No, everything is there, my lord.
Please read.
My lord. Whoever conspires or attempts to commit or advocates, abets, advise or insert directly or knowingly facilitate the commission of a terrorist act, or any act preparatory to the commission of a terrorist act shall be punishable with imprisonment for a term which shall not be less than 5 years, my lord. Directly it is not there, but abatement and all these things are there, my lord.
Abatement for a terrorist act.
Yes, my lord.
Not
right, my lord.
Not for raising funds. That's a distinction.
That may be, my lord. But the court went to say that since 120B is there, so 18 is superfluous.
That was not the reason that the conviction was under section 17. So 18 would not apply.
That way, probably it was not said, my lord. It was said that since 120B.
In effect, 18 applies only when there is a terrorist act, which the court itself has given a finding. No terrorist act. It's only funding. For funding, whether
No, all other terrorists are not funding, my lord. They are for taken into task for other offences.
There you're right. There you're right.
Yes, my lord.
Those who are not convicted for 17,
yes,
they have a valid argument of 18.
18, my lord.
120B vis-a-vis 18.
18. That is my way of saying things, my lord. And that thing also happened in regarding to the interpretation of section 38 and 39 before the Honorable Supreme Court, my lord.
What do these sections read?
Yes, my lord. 38 and 39. While interpreting the Honorable Supreme, the High Court said that 39 is superfluous.
They are just perimeteria for an organization.
Yes, ma'am. And terrorist organization and support, I read, my lord, offense relating to membership of a terrorist organization and offense relating to support given to a terrorist organization. So these are in the two different diametrical way, my lord. So in this case, my lord, I just wanted to stand myself correct and see that future nothing wrong happens, my lord. Para 17, my lord.
So come out, the definitions of right and wrong keep on changing.
Yes, my lord. Para 17, the Honorable Supreme Court, while dealing with that aspect, my lord, we must, however, state that the High Court was not right in observing if a person is punishable under section 38, section 39 becomes superfluous. In our view, the scope of these two sections and their fields of operation are different. One deals with the association with a terrorist organization with intention to further its activities, while the other deals with garnering support for the terrorist organization, not restricted to provide money or assisting in arranging or managing meeting or addressing a meeting for encouraging support for the terrorist organization.
Yes.
That's why I was tempted to point it out, my lord.
Okay. Yes. But there is no discussion 38, 39 vis-a-vis 120B.
Yes, my lord.
There are convictions for 120B also.
Yes, my lord. Yes, absolutely.
That was not interfered.
No. Because here the Honorable Trial Judge has written, my lord, the section, see 120B, who they have been convicted, my lord. So 18 becomes unwarranted. So if we interpret it, unwarranted is not wanted or unnecessary, so it becomes superfluous.
Right.
And your lordship is legally right, my lord, to say that that is not meant for funding, my lord. That is for terrorist activities, my lord.
Yes.
So, my lord, coming to the point in issue right now before your lordship is that whether I conspired with any person, my lord. So first, I'll submit, my lord, that there is no evidence on record or any material or any iota of evidence to show that and prove that the conspiracy aspect is between these accused and other person that I siphoned out. I may suppose, assuming for argument's sake, I may have misrepresented, I have siphoned out, but it's for myself, not for terror funding, my lord. I have got nothing to do with it, my lord. And I have shown certain circumstances where I have got no involvement. That is my respectful submission, my lord. Then if there is no evidence to show from which schemes also the accused appellant deflected and siphoned off the money and paid it. Because I didn't pay it from the pocket, that is for sure, my lord. The allegation is that the development funds meant for the state of, meant for the autonomous Hill District Council, my lord. I have siphoned off that money and have made it. And the larger, broader conspiracy was on 4 angles. If your lordship will look into the charge sheet, my lord. What was the original story, my lord? There were 4 grounds taken by the NIA, my lord, to entangle me with the conspiracy, my lord. Now, whether that allegation charge has been translated into evidence, your lord. My lord, from the charge sheet, my lord, if your lordship page to cover.
Volume 9, 2199.
My lord, volume 9, page 2199. Inner page to my lord. Directed 28 page 24.
Page
17.13, my lord. Page quadruple twos, my 4 twos, my lord. 17.13 is the para, my lord.
Yes.
Because of all these allegation, my lord, I was behind the bar, charges were framed accordingly, my lord. I was not discharged. But what are the materials that they have produced? Your lordship will kindly look into it.
Please.
The conspiracy angle as alleged by the NIA during the course
Para
of the-
number?
Yes, 17.13.
Yes.
During investigation of Bokhisto PS, it is revealed that after the arrest of Fozendra Hosai A1 and Babul Kempra A2, Assam police recorded the statement of the accused and the police person who were involved in the seizure of ₹1 crore. The 2 drivers of the vehicle were not arraigned as accused as they were not found involved and were therefore not arrested. The 2 pistols seized by the police were sent to the armor of the Assam police for firearm examination and identification. Fozendra Hosai and Babul Kemprai were taken to the police remand for interrogation. Later, they were transferred to judicial custody and both of them were enlarged on bail by the Honorable Guwahati High Court. Assam police also arrested Mohit Hosai A3, RH Khan A4 on 31st May 2009 and searched their house. From the house of RH Khan A4, an amount of ₹4 lakhs was recovered. This amount was part of a huge amount of money siphoned off by RH Khan as part of the criminal conspiracy to supply funds to DSDJ. Investigation revealed that Mohit Hosai was sending money to Niranjan to DSD and that the ₹70 lakhs, this is what I'm hammering, last time also addressed, 70 lakhs has been sent by Joyanta, by the contractor, 812, and the rest of 30 lakhs by RH Khan. So where is that 30 lakhs coming from, my lord? From which way it was siphoned off and from which scheme it was taken out and which bill it was paid and which, and during which period it was given to him, because this relates to the occurrence in 2009, my lord. To R.S. Khan, who was the Deputy Director in the Social Welfare Department in SRC. R.S. Khan was made the liaison officer of NSC in addition to the responsibility of the Deputy Director Social Welfare Department. On the recommendation of A.K. Burra, Principal Secretary, additional charge of NSC as liaison officer, he used to get the budget for NSD released by the state government and in pursuit of the state criminal conspiracy, provided the funds of DSD by fraudulently channelizing the funds of NCH. So this is the conspiracy angle that was projected by the NIA during the course of the investigation and while filing the charge sheet. Now the facts remain, my lord. Out of that 1 crore, my lord, it is said that 70 was paid by a contractor of PHE, my lord, which he has got nothing to do with this social welfare. And the social welfare department deflected amount of 30 lakhs was given. So now where is that evidence, my lord? Where is that consideration by the learned trial court? Nothing, my lord. Not a single line has been translated from these charges into evidence, my lord. It's nothing on record to say and suggest that this 30 lakhs, that from this scheme it was taken now. Because the accused appellant cannot take the money directly. He has to pay to some contractor and from him it will be only taken and then given. because the schemes are executed by the contractor, by the suppliers. So the check, money, whatsoever will go to them first. Thereafter, it may come to me. So that way, my lord, if your lordship will see, not a single contractor or supplier of social welfare department was examined as a witness to prove that angle. Now, where did the money just did not come from the top, my lord? It has to come from the bank, my lord. And to go to the bank, my lord, a check is to be generated. Bank transaction has to take place, my lord. Then only the money will be given to that person concerned. Now, who received that money? It is the contractor and supplier. It says NIA did not find anybody during the investigation of the case that money was given to such contractor. Unlike the PHE department, my lord, the contractors are there. So there is only one person, of course, that is there. Devashish, my lord, is one of the contractor, my lord. But he has been also discharged from the CBI is still going on for him also, my lord. So that aspect is only there, my lord. Beyond that, there nothing has come. So these 30 lakhs, where did I pay and to whom did I pay, my lord? That is not coming forth, my lord.
Yes.
So again, we like to take your lordship to para 17.24, my lord. Because that aspect will take care. 2227, my lord. Inner page 24.
Yes.
25. 29, sorry. 17.24, how the method was used according to NIA to siphon the government fund, my lord. And with all respect, I'll say, my lord, the same thing without any evidence has been quoted in that recapitulation, my lord. If your lordship will see the paras, my lord. Investigation revealed that accused R.S. Khan used the following method to provide funds to CM Mohit Hojai. Your lordship will take note because nextly what they will use, we'll see also. The name Mohit Hojai surfaces for sending it to DSDJ for supporting their activities. Took private person in confidence and obtained their signature on blank bills, received voucher, illegally got them filled up and used the same for providing fund. Made bogus, fictitious bill, vouchers, receive and use the same for providing fund. Obtained supplies from non-registered suppliers, contractors, and took his share of the bills paid by them. Showed exaggerated supply to Anganwadi centers for self-help group. Showed construction of safe drinking water tanks, disbursing the payment for the same without any construction on the ground. Obtained receipts of more amount but paid less to physically handicapped person. Directly took away funds from the bank without mentioning the same in the office record. Showed payment disbursing to adults and girls without actually doing so. Last line, my love. To do the acts mentioned above, R.S. Khan treated his employees who obeyed his orders to fear of the life. So there is no evidence as such. One person said that I was given sometime some languages were used, my love, but he was already transferred by Dikestem, and in his 161 he was never stated all these things. For the first time he introduced in the code. So the four more lines from next para, my lord. Then the conspiracy part 8, my lord. R.S. Khan. Investigation has further revealed, para 17.25. Investigation has further revealed that R.S. Khan entered into a criminal conspiracy with Jayanto Kumar Ghosh, 812, and others. Now, who are those others, my lord? Nothing has been brought because in a criminal case, everything should be specific and pinpoint. And in furtherance thereof, showed the payment amount of rupees 32,07,800 in the year 2009 against supplies to different firms of JK Ghosh A11 without any supply of material. Thus, R.S. Khan from the above act used to generate the fund to finance the terrorist activity through Niranjan Hojai or purchase of arm of DSA. As I've said, the name now comes in Niranjan. Earlier it was Mohit, my lord, on the opening line. So what I want to say, my lord, the NIA inspector, the person who filed the charge sheet, my lord, PW 150, the CIO, who is himself not sure, my lord, through who is the person. Suppose prima facie going by their own statement, own averments. So if your lordship will see now that all these modus operandi, which is said to have been adopted to siphon of the money, my lord, has been recapitulated and has been taken into account, or I will say to an extent, copy pasted it, my lord, without leading any evidence, translating into evidence, my lord. Because these are all mere saying at the time of charge, my lord, the charge sheet will only speak whether there is a prima facie case or not.
Right.
But in trial, my lord, evidence has to be lead to prove those charges. So those charges were never brought into record, neither there is any charges that I deflected the money, my lord. So first they must show that by what way I and who are the witnesses from where the money I generated, my lord. Because I was not paying it from home. It was that I was in the government service and I made a person sit in the chair of the CM, and thereafter he took charge, and we in conspiracy gave him the money for his inwards transmission to the DSDJ. That part is completely lacking, my lord. The chain of events is not there, my lord. Neither there can be any inference to that aspect, my lord. Because not a single witness has come forward or taken the doc to show, my lord, from which bill, which scheme, which vouchers, which payment, my lord. And the cash book was also produced, my lord. Rather, Exhibit C will prove the fact that there was surplus amount lying in the bank account, my lord.
Yes.
That is my respectful submission. So far, 120B is concerned, my lord. So again, from reading from the judgment, my lord, that part just I'll throw light, my lord. Your lordship, I'm sorry. I'll just read because how the learned trial could dealt with it, my lord. It is and the who were the conspirator. What was the conspiracy and who was the conspirator? No, I have. Yes, sir. Yes, super. 1899 of the judgment, my lord.
Para.
Para 14, my lord.
1-4.
Yeah.
Yes. Rather, I would like to start from the top, my lord, para 12, for your lordship appraisal, my lord. Because conspiracy is the ultimate section which have been used for all the accused, my lord. Yes. To better understand the matter, my lord, you start with what was the conspiracy, my lord. Now, whether my submission are based on material or record or not, my lord. Here in this case, it is submitted by the learned special PP Nia that a conspiracy was hatched for waging war against the state, and in furtherance of the state's conspiracy, it was also conspired to overweigh the elected regime of North Kachar Hills Autonomous Council led by Dipolal Hujai, and thereafter to deflect development fund meant for development of NCHAC, and to provide the same to the DSDJ cadres for procurement arms and terrorist activity as to achieve the aforesaid goal, my lord. Now, Dipolal Hojai comes to the witness box as PW 126, and he says that I was not forced to resign. No threat was given by any terrorist gang. My lord, I simply resigned on my own medical ground.
Ill health.
Yes. So that submission itself is nullified, my lord. Now, who were the conspirator? The person included. It is submitted by the learned special PP that Mohit Hujai, government servant R.H. Khan, Purna Soikia, and contractor, all the names are given, my lord. I need not read, including arms suppliers were the conspirators. Then where the conspiracy took place? It is being submitted by the learned special PP that the conspiracy took place at Haflong, the district headquarters of Dima Hasao, the erstwhile North Kachar Hill. It is further submitted that to further the main conspiracy took place at different places. One such part conspiracy that took place at Haflong comprises of overthrowing the elected regime of NCHAC led by Dipolal Hujai and deflection of government funds meant for development of NCHAC and committing terrorist act to terrorize the people and to wage war against the government. The second part conspiracy as submitted by the learned special PP took place at Guwahati in the month of March 2009, where a meeting was held at Hotel Pragati Manor between Mohit Hojai, who became the CEM of the NSC, and after overweighing the elected regime of Dipolal Hujai and the government officers and contractor. It is further submitted that in the same meeting, decision has been taken to issue advance check, and accordingly checks were issued in advance without and work order and execution of work. The check was encashed and huge amounts of the sum were entered. My lord, in this paragraph, I'd like to add, my lord, this relates to PHE, not to the social welfare, because while taking the evidence on record of the learned trial judge, my lord, this evidence which were laid, my lord, by the NIA, my lord, relates to PHE department, not with the social welfare department. So whatever is attributed here in this para relates to PHE. I am not way connected with it, and as the lordship has got it, that those witnesses has nothing to do with the events that took place in this hotel, my lord. Because many subsequent developments are there, my lord. I'll not go into that arena because it is for the person concerned. They will be defending themselves. Then your lordship will come to know on that aspect. But if your lordship want to read that aspect, I can read. But since it is no way connected to me, I have made it clear, my lord, that this hotel Pragati incident has got nothing to do with the social welfare department. My submission is that it is with the PHE. Then the third conspiracy, according to the learned special PP, took place at Kolkata. That is regarding US dollar, conversion of dollar from rupees to dollar. It is alleged that a third conspiracy, the siphoned out money was sent to Kolkata by various means, including Hundi operators, to convert the same into dollar so as to purchase arms and ammunition. The fourth part conspiracy as submitted by the learned special PP took place at Aizol, where after payment of the dollars, the arms and ammunition were received and sent to DHG to wage war against the government. That is for Vanlanchana part, I throw like my lord. Now it is to be seen how far the prosecution side has succeeded in discharging its burden. It is to be mentioned here that all the accused have been charged under this section, that is 120B. As mentioned in paragraph 9 above, all the accused persons have engaged a different set of lawyer. So that is regarding submission. I escape it, my lord. Shall I read? This is regarding that all different.
You may ignore that.
Yes, my lord. Then we'll come to the individual role played by each of the accused, my lord. The first dealt with the Babul Kemproy and Fazindra Hosai, my lord. How much would you remember? 1944, my lord, the part while dealing with my para 128. Your lordship got it, 1944, para 128, while dealing with the conspiracy part and the role of the accused, my lord. That I have already read it, my lord. So these are that part, my lord. Following the proceeding, the document exhibit will show the role played by accused card. Already I have taken your lordship on the last occasion, my lord. So if your lordship also come to the recapitulation part, my lord, we'll see the modus operandi has been clearly mentioned on there, my lord. 1944. 1994, my lord. Your lordship has already read it, my lord. I was just showing, my lord. 1944. All the my lord, para 164, my lord.
Yes.
The same thing, my lord, which is already mentioned in the charge sheet, my lord, has been just brought in. I will not say copy paste, my lord, has been just brought in and put in here, my lord, without any appreciation of evidence and without any material evidence on the record, my lord.
Yes.
If your lordship will compare it with the charge sheet as a comparative statement, I can make a comparison. But if your lordship will look into, so I did not enter, my lord. Shall I? Or 17.24 no more charge. The same metals has been, my lord, simply taken into account, my lord, brought into account from this 17.24. The methodology used, my lord, as the NIA says, my lord. But not straight directly, I will not say that, my lord, but with variation, my lord, the same thing has been incorporated here. And that thing was during investigation. And that has to be translated into evidence and not simple evidence, my lord, beyond all reasonable doubt evidence. Substantive evidence is that whoever comes to the witness box and depose, my lord, that will be a substantive evidence, my lord. No evidence has been laid. On the contrary, my lord, there are positive evidence against the accused person showing that all the works of the NC, not Kasar Hill Autonomous District Council, were properly implemented. Money was paid to who were the supplier and contractor as per norms and following all the rules. So where did I siphon of the money? And to whom I gave that 30 lakhs? From where do I get that 30 lakh? No evidence at all, my lord. So, my lord, if your lordship will see, the first point that I would like to show that whether they have come up with a designation by saying that I was working as, in addition to my normal duty, Deputy Director, Social Welfare, I was working also liaison officer, and whether that fact at all has been established or not, my lord. Because if for that point, my lord, I'll take your lordship. PW 23 is the only person who has stated in a different manner, but it has been quoted in a different manner. And vis-a-vis, there are other evidence appearing, my lord, positive evidence to show, my lord. I'd like to take your lordship to PW 23. In my paper book, your lordship will get it.
Yes, page 27.
Yes, ma'am.
27.
Running page, my lord.
Yes.
Page 37. No, my lord, that is 25, my lord. I'm on 23, my lord, right now. Because by taking 23 into consideration, this thing has been dealt with. Kulendra Dolagappu, my lord.
You're reading Kulendra Dolagappu?
Yes, my lord.
He's at page 27.
Yes, my lord. No, he's at page, my lord, 29, my lord. Kulendra Dolagappu, PW 23. My paper book running page. Oh, yes, my lord. I think it's 29, my lord. Anyway, if your lordship.
Anyhow, whatever, it starts at page 27.
Oh, yes.
Or in our paper. Maybe there might be some
Yes,
pagination issue. Yes. We have Kulendra Dolagappu.
Yes, my lord. The 79 is that relevant part, my lord? Because that was taken into account, my lord, while finding that I was also one of the, I was working as the liaison officer. But the court took it that way, my lord. So there are positive evidence to say, my lord, regarding now, no, PW 126, my lord, I'm so sorry.
You're not reading Kulendra Dolagappu?
No, no, my lord, I'm sorry, my lord. I went for finding number 3. I mistakenly said, my lord. Sorry, my lord. It should be finding number 2. No evidence at all that I was the liaison officer, PW 126. And there are and PW 156 and 150, my lord. Both has to be read together, my lord, to see whether.
The Polan.
Yes, my lord. Yes, given. Six to 8 to plus start. Minus. My lord, cross-examination of R.H. Khan, my lord. Second line, during governor's rule of NC Hill District Deputy Commissioner of NC Hill became the sole administrator and all department used to work under him. I only know that accused R.S. Khan was the Deputy Director of Social Welfare Department, NC Hill. That is the only line, my lord. I only know that accused. Now, if we come to the other evidence, my lord, who was the EM, my lord, executive member of the social welfare department, who was the best person to say, my lord, when he was cross-examined, my lord, PW 156. Before jumping that, my lord, let's turn to page 6 to 8, running page 314, my lord. That is the only line that was considered to find that I am the liaison officer, my lord.
PW,
Same PW 26, my lord.
yes.
At page 628 of the paper book and my running page 314, my lord.
Dipolal,
Yes, my lord. Where did the judge found that I am the liaison officer, relying on this line, my lord? And in cross, he has said,
I know R.H. Khan.
yes, ma'am, absolutely. I know R.S. Khan, he was the Deputy Director of Social Welfare. Stop. I have heard that during the time of the governor's rule, I became CM. He was also working as liaison officer. Though he have heard it and he have stated it, ma'am. That is one. No official document. If I am an officiating my duty as a liaison officer, there ought to have been an order issued. There ought to have been a gazette notification to that, my lord. Or simply an office order I would have sufficed the matter had it been brought into record. On the contrary, now I showed the positive evidence to the CIO also. The CIO's PW 150, my lord. What he has got, if your lordship will put me a question whether you have put it into the IO or not. Yes, my lord, we have put it. And what the IO has got to say into this account, my lord. He says, my lord, that I have not submitted or seen any documents in the court to show the result. Page 817 of the paper book, running page 409.
409.
Yes, my lord.
It's not there in this paper.
Mother, I have given you, my lord. Paper book 817. I will distribute for me. We have given, my lord.
All right, we have it in another paper book. Read.
Paper book page 817, my lord.
This is what you have given, this ends at
My lord, last two pages, my lord.
last witness is 141 in this.
150 is the IO, my lord.
147. You-
All
right, we are having another paper book.
Yes.
Don't worry, read.
Volume 4, page.
But we are having it. We are having it. Yes. Read, please.
Yes, my lord. So 817, I'm reading, my lord, in the middle, my lord. It is true that I have not seen any
Internal page of IO.
internal page is 61, man.
IO.
IO, my lord.
Yeah, 61.
CIO, my lord. Chief Investigating Officer.
Yes.
My lord, the paper book page is 807.
Yes.
817, running page 409 in my paper book. And the internal page is 61. It is true, my lord, and the second para, my lord. It is true that I have not seen any exhibited document in the case record mentioning R.S. Khan as the liaison officer. And now another important aspect, PW 156. Yeah, it is page 1 now. Even I want you to see paper book. I'm a favorite question to you. EM social welfare. 156. Oh, 150. Oh, para 156. Probably 79 and 98. Kuntu.
156.
No, 156. No, I'm sorry. That is para 156. Here's the evidence. Court has dealt with it. Then
no
comes to
156.
PW 79 and 98, my lord. 98 will start first. Paper book, my lord, paper book volume 3, my lord, because these are not relied upon evidence. That the positive evidence appearing, which was not taken into account, my lord. Only the negative one line has been taken, that too when hard, my lord. 98 to page given.
Paper book 559.
559, my lord. 599. 559.
Yes. 559.
Yes, my lord.
Nipolal.
It's an idea. No, ये तो पेज में है, 558 तो पेज में है. During my tenure, my lord, I'm reading from the chief Nilupul Hujai, my lord. That dictionary. During my tenure as executive member of Social Welfare Department, R.S. Khan was the deputy director of Social Welfare Department. That is coming in the chief, my lord. So the same. 561, my lord, opening line, my lord, on the top, my lord. R.S. Khan is only the deputy director of Social Welfare Department, Haflong, and he cannot manage the fund, my lord. That I was expert in managing fund and all these things are coming, my lord. That is not there, my lord. Now another witness, 8 to 98, 79 to be. And he was the EM of my department, my lord, where I was 79 to put in there. Yes, my lord. 79, my lord, PW, page, paper book 486, my lord. This is not, because the paper book consists, my lord, what was relied upon, my lord. So now I am reading the positive evidence which was left out by the trial court. Had he taken all this into consideration, he would have not arrived at this erroneous finding, my lord.
And you would not be required to argue this appeal here then.
My lord.
Then you would not be required to argue this appeal in this
Yes, my
court.
lord. My lord, 486 is the relevant page, my lord.
Yes.
My lord, he
Volume
is the one Mohindra Singh Nunesia and EM, my lord. I know second para, last line. I know one RS Khan. He was the deputy director of Social Welfare Department. That is coming out in the chief itself, my lord.
Part 1, volume 2.
Yes, my lord.
Yes. That's all you want to read from this?
Yes, my lord. That's the positive. My lord, what I'm trying to say, my lord, that one line that appeared in which was heard.
He was a liaison officer. That is just a hearsay.
Hearsay evidence, my lord. Rather, there is positive evidence that I was working as only, and that is coming in the chief, not in the cross that I manage or this or that.
Right.
In the chief, my lord itself, when the PP took into him in that witness box, my lord, he deposed that way, my lord. Now, my lord, regarding the deflection part, my lord, if your lordship permits me, the positive evidence that which tidbits, my lord. If your lordship permit me, I'll read those, my lord.
Yes.
Starting with PW 23, my lord. Because this your lordship will not find in my paper book for your lordship convenience, which I have given. Because these were all taken into consideration, which are not taken into consideration.
Kulendra Dalaga.
Yes, my lord. I have already read, my lord. PW 23. Then PW 25. He was the CDPO supervisor, my lord. Page 2, PW 25.
Yes. Monica swear.
My lord. That was also taken into consideration by saying her evidence was rejected, that she is a boss of, I was a boss, so she deposed in favor of me, my lord. Inner page 40, my lord. My lord, that your lordship will find, my lord, in my paper book also, because those positive lines were left over, my lord. Page 76, my lord, running. '76, my lord, running page, and internal page 40, my lord.
Yes.
I in the middle, my lord. 5 paras, my lord. You can list number line time. So, one wasn't to my line team number. Yeah. My lord, so for this phonica is considered my lord page 40, my lord. 5 para 5, my lord. I know that the Social Welfare Department NSC Haflong, the various welfare scheme, including SNP, that is Exhibit 62, and ICDS Exhibit 82 programs were properly implemented as per norms and guidelines of the government during the period 2007. Then if we go down, my lord, third para from the down, distribution of national old age pension, distribution of old age pension, state share distribution, family welfare benefit, NSAP scheme, healthcare scheme, rehabilitation of BPL persons were done as per the list of selected beneficiary and approved by the principal secretary of NCHC. Then thirdly, my lord, the payment of the beneficiary were disbursed properly as per guidelines of the government of Assam. During 2007 and 8 and 9, the distribution of water filter, mosquito nets, blankets, and the other scheme were done properly, and materials were received in full by the beneficiaries. The National Program of Adolescent Girl scheme has been implemented properly for the period of 2007, 8, and 2009. The looms and accessory along with jacquard machine were distributed to the beneficiary in respect of the Rashtriya Sam Vikas Yojana scheme, and also constructed workshed at different villages of NCL for the period. Likewise, all these things are there. Now, all these things in the charge sheet says, if your lordship will read the charge sheet and the judgment recapitulation, my lord, these are the schemes it was being said of, my lord. This is the scheme that the NIA is saying it was not properly implemented. Yes. Whereas their own, this is not DW, my lord, this is PW from their evidence only, it has been brought. And she was never declared hostile, my lord. Even, my lord, that one case from Maharashtra, my lord, Thackeray's case, even if after cross also, my lord, a person may be declared hostile to clarify certain things, my lord. That is a 11 bench judgment, my lord. My lord, one last line which I would like to add is, my lord, page 1, even paper book 131, inner page 47, my lord. My lord, from down, my lord, to para. During the period 2007 and 9, after verifying the related files of all the works of scheme under Social Welfare Department, it is found that the works were properly implemented as per norms, and there is no any misuse of money fund. My lord, from my paper book, my lord, running page 131, my lord, 83, my lord.
Whose statement?
My lord, PW 25.
83.
Inner page 47, my lord, of the deposition, my lord.
That is at page 81.
Yes, ma'am.
Yes.
83, my lord.
There's a paging error, sir. It's 81 for us. Yes, you read.
I always said better.
Yes.
Please go with the pagination. It always happens with me, my lord.
No issues, you read. Internal page.
Yes, ma'am. Internal page is 47, my lord.
Yes, we have it.
During the period second last, my lord.
Yes.
During the period 2007-9, after verifying the related files of all the work of scheme under Social Welfare Department Haflong, it is found that it works were properly implemented as per norms, and there is no any misuse of fund during the said period. So after verifying the records, this has come. So all these facts were not taken into consideration while dealing with this aspect of the matter regarding siphon of the money. Rather, one line has been taken from her is that she has been one time my boss, my lord. So that's why she spoke in my favor. Then, my lord, PW 30, my lord. PW 39, Prones Parvosa. He was at that time working as the LDF cum typist of the Social Welfare Department, my lord, regarding a SNP. If your lordship will see, my lord, his evidence in chief, my lord, it was simply exhibited the documents. Nothing about factual aspect has been said how it is wrong or how it is right. Only merely marking all the documents, my lord. Nothing beyond that has been done. Only one para which your lordship would like to see at inner page 2, my lord. Page 156, my lord, of the paper book, my lord. My running page says it is 104. In the middle, my lord, the above bills and challans and Angawati Center after delivery of the materials certified by circle supervisor and Anganwadi warder, the bills and challans come to my table for passing for payment. When the bills and challans are found to be correct, I put the seals, pass for payment, putting the amount, and after putting the seal of deputy director at the relevant period, deputy director was R.S. Khan, and putting my initial, I placed the bill before the deputy director for passing the bill. So my contention and submission will be this, my lord, that it is not I who passed the bill, it was prepared, verified, checked, then put up before me for my signature. Then I give my endorsement as the DDO, my lord. It was my duty, official duty to do that, my lord. Then again, if your lordship will go to internal page 71, paper book page 225, my lord. In respect of that very file, my lord. My lord, last, my lord. According to the exhibit 62, these are the files according to the NIA, my lord. These files money was siphoned off, which is not correct, my lord, as per evidence on record. According to exhibit 62, during the period of 2007 and 8 and 9 in SNP Special Nutrition Program Scheme, all the beneficiaries are fully benefited as per record available in exhibit 62. The SNP schemes as per guideline beneficiaries are following categories of 6 months, 3 years children and pregnant women and such. That must show, my lord. Then again, for this witness, if your lordship will kindly turn to running page 194, my lord, internal page 92. Gawal ma kali running page likhi. Mehi to diya dekho. Yes, my lord, in the middle, my lord. Third para, all the works done in connection with file number such, that is exhibit 83, because two files were exhibited from where the money was according near siphoned off. Exhibit 62 and exhibit 83. So these are the files, my lord. All the works done in connection with file number such, that is exhibit 83, were issued in accordance with the due procedure and norm, and there was no any irregularities done in issuance of the work order by the Office of the Deputy Director Social Welfare, Haflong. Next, the Office of the Deputy Director Social Welfare, Haflong, has no any connection with DSD or any other anti-social organization at any period of time during my service. Then down below, my lord. So far, my knowledge is concerned during the period 2007 and 8 and 8 and 9, all works under the various schemes under the Office of Deputy Director Social Welfare NC Haflong were properly implemented as per norm, and there is no any misuse of money government fund during this period, particularly the scheme which I was dealing and other scheme in general. Then next page, my lord. During the period 2007-8, the distribution of scholarship and physically handicapped student rehabilitation grants of physical handicapped person under the scheme of welfare physically handicapped were done in public meeting in different places in presence of principal secretary and CHAC, CM, EMs, MSc, including other office and dignitaries, and such distribution were made in cash and kind to the selected and approved beneficiary. Now last para, one last para, my lord. The meaning of RSB, that is in the chart sheet, your lordship has got it. That is Rashtriya Sam Vikas Yojana and RSVY is 100% person funded program of central government and fund of RSVY has been received through the Deputy Commission. How long? I am dealing assistant of RSVY scheme since introduction of the scheme, and the scheme of RSVY was implemented properly under the chairmanship of the Deputy Commissioner NC Hill, and RSV schemes was commenced from the year 2004-5 to the financial year 2011 and 12. So these are the allegation in the charge sheet, my lord, as I have read it out in the 17.224, my lord, that this is the way the works were not done, money was directly siphoned off, my lord. So in the contrary, the evidence speaks on the contrary, my lord. And one example which I'd like to say, because all the bills that were exhibited, my lord, has been made into photo, pasted, my lord, changing the particulars. So every paragraph speaks like that in the other evidence, my lord. Inner page 95, my lord. Just one line I'd like to show, my lord. In every para, your lordship will find that, my lord. Third para I'm reading, my lord, or any para random thereof I can read. Exhibit 72, Person Chaudhary, who's approved government contractor, suppliers and the bill submitted by Salanchas against the work order number such, and after receipt of the articles, the office of the deputy director certified that articles have been received in good condition and recorded tendered into stock register number 36 by page number such and such. And thereafter, one of the deputy director social welfare, and thereafter, sorry, office of the deputy director social welfare may have passed the bill, and the bill was passed by the exhibit such by the deputy director social welfare, and the bill was passed as per due procedure and government norms. So when all procedure was followed, my lord, the person concerned is saying, my lord. So all these things were never taken into consideration, my lord. Then I'd like to show, my lord, PW 45. PW 45, my lord, my running page is 273. Paper book page is 361, my lord. Internal page is 15, my lord. Last line, my lord, just 3 lines. Last below 3 lines. After approval of the scheme, should be been a comma. The district council sends the copy of the approved list through principal secretary to the office of the deputy director social welfare and the other scheme to the other office. After receipt of the list of approval scheme, the office of the deputy director social welfare Haflong prepares the budget proposal and sends to the district council, and in the district council, most probably again, and in the district council has been wrongly typed. District council session, the budget is properly discussed. So in district council, they are like our assembly, my lord. So discussion take place, my lord. And district council session, the budget is properly discussed and finally prepared. And after finally prepared, it's sent to the HAD Hill Area Development Department, Government of Assam, Dispur for fund. And thereafter, the HAD send it to the legislative department, and legislative department produce it to the assembly session. And in assembly session, the budget is finally approved. And after finally approved, it is sent to the budget section of Finance Department, Government of Assam, Dispur for release of the fund. Then Finance Department release the fund, and it is sent to HAD, and thereafter the HAD publish the budget for the year, and copy of the budget is sent to the district council, and district council sends a copy to our.
This has nothing to do with your case.
No, I am submitting, my lord. Just one line.
Yes.
I am submitting because of the fact, my lord, they want to say that I just stole the money and give it to somebody. So here they want to say that the farms were fictitious. So, but it is the other way, my lord, how the money comes into the office, my lord. And this were the budget way, my lord, the approved list was not done by me, my lord. Approved list came from the council, the contractors, my lord.
Council was nothing but, as per them, it was
my lord.
Mohit Ujai.
Yeah, exactly.
That was the council.
Council was run by collectively, my lord.
Right.
Because it was the office, my lord. Council. These are the person who were taking charge for the constituent assembly type, my lord. So they used to discuss, my lord. Now what the office used to do, my lord. So if your lordship will just bear with me for 3 minutes, in the middle it will come, my lord. After the budget comes in, my lord. I read it because of to show that, my lord, money is not stolen, my lord, it's not a haste, my lord. It comes in a manner, my lord, and it has to be spent in a manner.
Yes.
And now that regarding the fund after receipt of the fund by the council, the social welfare department for execution of the scheme seeks approval list of the supplier contractor and approved list of beneficiary from the district council, and district council sends the approval list of supplier contractors and approval list of the beneficiary through the principal secretary to the office of the deputy director social welfare Haflong, and thereafter the department sends a letter to the ANFS for approval for to the principal secretary for release of the fund. So council is doing everything, my lord. Fund is the manner how to get the fund. They said the license officer I used to come to dispose, pay 10% and take the money. There I took it into my account and I paid everything to DSD, my lord. So that is not bearing out from record. Record says, evidence says otherwise, my lord. So there is no fictitious farms connection, as the trial judge while recapturing has said that the farms were fictitious or non-existent farm. The postman comes and depose also. One postmaster, if your lordship remembers it, definitely will remember it. My lord, those things are nullified by this evidence, by. We take it into account what the council sends it to us. It's not that we on our own do it. Council has given the list. From the list, we have done whatever it is to be done, my lord.
Right. Yes.
So I leave that, my lord. Now coming to PW 45, one line, my lord. Page 2. Rankal. Rankal, we finished it, my lord. Sorry. PW 80, my lord. It is not in this book, my lord, because that was never taken into consideration. In the paper book, it is there, my lord. He was declared hostile thereafter, my lord.
Volume 2. Yes.
Paper book. Page 489. He was LDA, my lord. Potik Chutia. My duties in the said ICTV project includes to assist the supervisor in the distribution of food items like rice, dal, sugar mill for distribution to the Anganwadi worker. So all these things have been brought to the wisdom of the public prosecutor, my lord, since he has resigned from his earlier statement, that is 161, no 164. So he was declared hostile. Next page, your lordship will see the cross-examination part made by the prosecution. Why I am reading, my lord? To show that how things were moving. I think I read it. My lord, one line that has come, why he was declared hostile? Because he deposed while distribution of food items, the supplier used to bring challan where the quantities of the items were filled up, but the signature of the workers and supervisor are obtained after distribution. I gave statement under 161 to the police. Now the cross part of the learned PP, my lord. Cross-examination by prosecution. It is not a fact that during my statement under 161, I stated following before the police on delivery of the food items to Anganwadi center. The signature of Anganwadi workers or helper was obtained on 3-4 bank delivery, blank delivery challan. This being done in order of R.S. Khan and then the Deputy Director Social Welfare Haflong. It is not a fact, now your lordship will say, it is not a fact that I have deposed in favor of R.H. Khan because he has influenced me. It is not a fact that I have deposed in favor of accused R.S. Khan because he has threatened me. It is not a fact that I am under inducement and under pressure from the accused. Here, I will just like to point out, my lord, I was facing the trial. I was behind the bar for 8 years since my date of arrest. So from jail, how can I threaten him, my lord?
That you don't ask us.
My
So
lord.
don't seek our opinion.
My lord, I'm sorry to say, my lord, but I'll definitely say a person facing trial as an UTP, my lord. These things will not be in consonance, my lord. Then my lord, in the cross part, two lines I'd like to put it, my lord.
How do people win elections while being in jail?
Yes, my lord, that is what. So many aspects comes into if we see in the broader spectrum, my lord. After distribution of the foods item, cross of RH Khan, my lord. After distribution of the food item, the Anganwadi workers put their signature against their Anganwadi centers and thereafter concerned supervisor countersigned the delivery challan. Suppliers and supervisor remain present at the time of distribution of the food item and concerned supplier also signed on the delivery challan in my presence. Under the office of the Deputy Director Social Welfare Hapong, there are 5 members of ICD projects. They are such and such. So it is only in presence of the Anganwadi worker and the supervisor, the things are done. And for that, they have examined only 2 witnesses, only 1 Anganwadi worker out of so many Anganwadi workers. And that too deposed in the matter, my lord, that was appearing in the records, my lord. Then another 2 witnesses, my lord. Now coming to the main part, my lord, whether the technical, now these are the factual aspects part is over, my lord. Now, my lord, there is an evidence, my lord, regarding some retrieving of data from the office computer to link me with Mohit or DSD. So whether that aspect has been properly dealt with it or not also, I'd like to throw light, my lord. That is one PW90 BC Ramani, my lord. The learned trial just took it into consideration, my lord, while conducting me. He is an FSL man of CDEC, my lord.
PW90?
Yes, my lord. My lord, my running page is 295, paper book page is 517, my lord. The paper book. My lord, before
Paper
that,
book is?
my lord.
Paper book is?
Paper book is 517.
517.
Yes, my lord. 507, running page is 295.
Yes.
My lord, your lordship will be, I'll be taking your lordship to some documents, my lord. So I place the paper book, my lord. I'll read the statement. I just kept it, my lord. I'll use it when required, my lord. Because his report is there, my lord. Exhibit 306, my lord, which was forwarded by Exhibit 305, my lord. So his first line, I am in engineer, I was the head of the cyber forensic. This line, if your lordship will now see in the cross what he says, by the is not a reliable witness. Why I say in 2009, I was the head of the cyber forensic section CDEC Trivandrum. That is his statement. But if your lordship will see in the cross what he has said, what does it mean? On 14/10/2009, I was working as additional director CDEC Trivandrum. Vis-a-vis, my lord, I'm showing.
Yes.
Then, my lord, if your lordship will see, I'll read just small paras, my lord. On 11/7/2009, a letter was addressed to the director CDEC Trivandrum by Loknath Behra, NIA, for examination of material objects like hard disk, CPUs, in total 14 objects. Exhibit 304 is the said letter in 5 pages. The letter mentioned the nature of examination. One was to find out any deleted file that could be retrieved, and also any file which is pertinent to sanction of work, supply order, to contractor, copies of emails, deleted files in the email, travel documents, if any, accounts, both personal as well as official information of DSDJ, photograph, pictures, contact numbers, available communication with Mohit Hojai, RH Khan, Niranjan Hojai, Daniel Dimasa, David Dimasa, Marung, Shubha Ghosh, Joyanta, Partha Varisha, Joel Garlosa, etc., and any other relevant network. My lord, this they wanted to link with to say that whether I was conspiring with the other person, but nothing as such was found. Technically, to nothing happened, but certain documents relating to one probably to Mohit Hojai was probably taken into account from that computer. For that, I'll submit on merit that I have got no connection or anything to do with that. Then NIA has sent the 7 hard disks from the CPU, my lord, for examination. As we required blank hard disk for making a copy of the 7 hard disks sent by NIA So we requested for supply of 4 high capacity hard disks of 500 GB capacity. The same was supplied to us. Upon receipt of the hard disk, we carried out the forensic imaging and ensured the authenticity of the evidence by generating hash values of the 7 hard disks and then did the analysis. In this analysis, we have looked at the retrieval of the deleted file information in the unallocated areas of hard disk, keyword searching, examination, textbook, PDF files. After the analysis, we have found some deleted information relating to PDF file, picture, etc. We have retrieved this information and submitted our written report along with DVD to NIA. Exhibit 305 is the forwarding letter dated 14/10/2009, and Exhibit 306 is the report of analysis in 25 pages with seal of CDEC. Exhibit 306 is my signature. Exhibit in our report, that is Exhibit 306, we have concluded that we have recovered few bills, challans, and work order. We have also recovered some pictures. We have extracted evidence from unallocated areas of hard disk. In the report, we have induced DVD, included DVD, which is organized exhibit-wise 1 to 7. These exhibits contain images, files, Word file, PDF file. In continuation of my deposition before the Honorable Court, I further state that after examining the materials object, we had prepared a report. We means other person is involved, my lord. Prepared a report and returned the material object along with the report. Today, I have seen the Dell laptop bearing number such. The laptop contains the hard disk such and marked as such, and articles were sent to us to show to have been seized from Kulendru Dalagapur. These have been examined and submitted our reports. White Exhibit 306 at page 5 and 6. The laptop exhibited as material object number 77 is the Dell laptop bearing serial number such. This is for Dalagapur, my lord. For me, my lord, next para. The hard disk bearing serial number such, which was marked as Exhibit 2 by NIA when the articles were sent to us and is shown to have been seized from Phonica Square and is shown to me in the court today, which is seal condition as sealed by us. With the permission of the court, the seal is open. We had examined and submitted a report, White Exhibit 306 at page 8 and 9. The hard disk is exhibit at material object 78 and bearing serial number such. So 2 exhibits were made from my computer, my office computer, 78 and 79. Next paragraph deals with Exhibit 79. The hard disk bearing serial number such, which was marked as Exhibit 3 by NIA when the article was sent to us and is shown to have been seized from Phonica Square and is shown to me in the court, which is in seal condition as sealed by us. With the permission of the court, the seal is open. This we had examined and submitted our report, White Exhibit 306 at page 11 and 12. The hard disk is exhibited as material object numbers 79 bearing serial number such. Next, we are not connected. These 2 are relating to us, my lord. Then, no, one more is there. 520, my lord, deals with another part of my Lenovo laptop, my lord. Lenovo CPU. Next page, 520, third para. The CPU, Lenovo bearing model number such with serial number such, the hard disk bearing model number such was taken out while examining, and the same was sent to NIA office in seal condition. The hard disk with model number such, which was marked as 07 by the NIA when the CPU was sent to us, is shown to have been seized from RH Khan. This we have examined and submitted a report, White Exhibit 306 at page 23 and 24. The CPU is exhibited as material object 83 bearing model number such and such. So my lord, here, my lord, one really astonishing thing has happened, my lord, that it was says to be seized from me, my lord, in to 10 some other date, my lord, which was I was in jail probably, my lord. So that cannot be so because of the fact either I have to lead it for discovery because I was an accused, my lord. At that time, when this date was given in the cross, it has come, my lord. It was at the period when I was in jail, my lord. So
That you will have to show us.
So sure, ma'am.
PIO.
Yes.
Investigating officer.
Yes, my lord.
Yes.
The date, my lord. The Center for Development of Advanced Computing, CDEC, was established in 88 on 14/10/2009. My lord, from the cross part, I am now reading, my lord.
Because this is what deals with RH Khan, so I'm dealing his part only. Cross-examination of RH Khan, the page 521, inner page 5. The Center for Development Advanced Computing, that is CDEC, was established in 1988. On 14/10/2009, I was working as additional director of CDEC. That I showed the difference, my lord, that he is not speaking the truth. Exhibit 304 is the letter of 6 pages which was sent by NIA. I am not aware who has affixed the signature appearing in Exhibit 304. In Exhibit 304, the name of Loknath Behra is not mentioned. He said in the chief, it was Loknath Behra who has sent it. I have no knowledge who was the IO of NIA case number 1 of 2009. In the report, White Exhibit 306, it is not mentioned that the CDEC NIA for supply of 4 high-quality, high-capacity hard disks. I do not recollect the date on which we received the 4 high-capacity hard disks from the NIA. The statement that I determined the hash value of each of the hard disks before examination is not mentioned in my report Exhibit 6. The report consists from page number 1 to 25, and from page number 1 to 25, there is no signature of the examiner or any other officer. Actually, it was a preliminary report, my lord. Finality could not be led into this conclusion because of the fact, my lord, the CDEC asked for certain documents which we, if you want to carry forward, please tell us which document you need. The CIO or the IO never wrote or revert back to this CDEC.
Where do you get this from?
Yes, ma'am. I'll get it, ma'am. The report consists from page, we have it, ma'am. The report consists from page number 1 to 25, and from page number 1 to 25, there is no any signature of the examining order officer. As per our request, NIA sent the hard disk to us, which are now in our office. In our observation made by in my report, in page number 12, I have mentioned the materials marked by NIA. Exhibit 3 does not contain any image, PDF, and other files relating to DSD. Exhibit which was sent by NIA for examination by us were examining by Satish Kumar. He is not the maker of the document. I have not personally examined the article sent by NIA, but I have sat, he only sat with the Satish Kumar and verified the report. Satish Kumar is the person who gave the report. Satish Kumar is alive, but he is not with the CDEC, not cited as a witness also in the charge sheet. I have not personally prepared the DVDs for retrieving the deleted files from the hard disk. Some software are generally used, such as Stellar, Phonex, recovery my files, etc. It is not a fact that forensic image is sometimes referred to as mirror image or ghost image, but I am not aware whether a mirror imaging or ghost imaging does not always generate a true forensic image. It is not a fact that every hard disk has built-in hash value. Exhibit 305 is a preliminary inquiry report and it is not a final report. The preliminary report number is CDF such and such as mentioned in Exhibit 306. In 306, the preliminary report number is mentioned as such. It is correct that Exhibit 306 in the head investigation at page number 25, it is mentioned that the material object related to the above mentioned crime was submitted in CDEC Trivandrum on 14/7/2007. In Exhibit 306, from page number 1 to 25, in every page, it is written as report number such. It is correct that examiner K.S. Kumar has not produced any certificate along with the DVD made by material exhibit 84 to 85. It is correct that the DVD and CD are different thing in regard to capacity. In Exhibit 305, it is mentioned that regarding the enclosure of preliminary report along with 2 DVDs, one original and the other is a copy of the original. In page number 9, Exhibit 306, in point number 2, it is mentioned that all these recovered items are included in a compact disc and are attached with its initial report. In page number 12, 24, 25 of my report, Exhibit 306, only the word compact disc is mentioned and DVD is not mentioned. We have not provided any guidelines along with the report as to how hard drive image can be done. At the relevant time, I was the head of the cyber forensic group of CDEC Trivandrum. So this is the now that part I would like to show. Yeah. My lord, if your lordship will take this 306. The 25 page, my lord, it starts from 17, my lord, page.
Rather, it starts from page 16, my lord. Exhibit 305. So this PW90 writes this letter to Loknath Behra, my lord, IPS, National Investigation, Ministry of Home Affairs, Government of India. Reference card number 1, near New Delhi. We have enclosed the preliminary analysis report and also attached 2 DVDs. Kindly note that we have received adequate data from submitted and hard disk exhibits. The DVD contains folders with files from each exhibit arranged by their exhibited number. Each exhibit folder contains subfolders. All these files can be viewed depending on the ability of the following software. In order to speed up our process for the final report and submission of the same, we request the investigating officer to go through the retrieved data on DVD and let us know the corresponding files with their path and file name that is needed for the prosecution. On receiving this data, we could work on the final report at the earliest. Kindly need the needful. So they wanted something more, my lord, for which they have written it. Now, if your lordship will see, the first note itself says exhibit 306, my lord. Actually, in the paper book also, my lord, I'd like to point it out, my lord. The office has only supplied 1 page, my lord. The whole thing is not there. How did you got it? If your lordship will put the question to me, my lord. It was the copy that was supplied during 207 stage, my lord.
Right.
So office paper book, your lordship will not get the 25 pages. It contains only this first page. But I have given it, my lord. I have given a copy to them also. They can verify it, my lord. Oh, no, all first page to listen. Baki 25 pages, 24 pages are missing. Then 18, my lord, is the cyber forensic analysis report. And I'd like to take your lordship to the relevant part at page 44, my lord.
44.
Let's go from 42, my lord, because nothing to hide, my lord. It's dealing with R.H. Khan, my lord. Nature of examination requested to see deck for exhibit 7Cs from R.H. Khan.
Yes.
Sir, no, you'll not get a copy of again. The paper book does not consist the 25 pages. So I have prepared it on my own. I have given a copy for his verification. Details of exhibit 07, nature of examination requested to CDX for exhibit 7C from Mr. R.H. Khan, Word files and Excel pertaining to accounts such and such, documents pertaining to preparation of any bill, receipt, challan given to January 2008 to 2009. Copies. Your lordship got it, page 40.
Yes, we are reading it.
Yes, madam. Letters of correspondence on.
Already, we have read it. What is the finding of the trial court on this report?
Finding nothing, my lord. That is what
What is the finding of the trial court on the basis of this report?
My lord, he has deposed, that was only taken into consideration, my lord.
What is been mentioned? The report gives no conclusion at all.
Not at all, my lord. Neither it is a signed document also. Your lordship will see not a single page is signed. But one moment, if your lordship will bear with me, my lord.
Yes, sure.
Just last page directly, my lord.
Yes.
How casually and perfectly things were moving, that is what I am interested in.
But you didn't put any question to the witness that he has not signed every page.
Yes.
You put the question.
I have read it personally, my lord. I assure you. I'll take it, my lord.
Yes.
My lord, now first, let me conclude this page 44, my lord. It will let you align to.
Yes, what were you referring to?
Yes, I'm referring to page 44, my lord.
Yes, we are having it.
Yes. My lord, this is just a preliminary report. Now the CDEC writes to NIA, my lord, saying what, my lord? All the exhibits that submitted as evidence for this case was analyzed, and there were few evidence retrieved. Some exhibit did not have any files pertaining to the investigation. However, we have managed to get relevant evidence from each exhibited and have attached them in the CD, each categorized under the exhibit name and type of file for easier access. For the final and detailed report, we would suggest that you select the particular file and interest and provide us with the corresponding file name from the submitted files for interest to provide us with the corresponding file name
for submitted CD. This will help us complete the report, giving more details of the selected file as to when they were created, modified or deleted. All the recovered items are included in the compact disc and are attaching along with this. So these things were never carried forward. It came to a halt, grinding halt out here. Nothing was done thereafter, my lord. And there is also furthermore no 65B certificate also, my lord. Once it was transferred, my lord. My lord, your lordship was asking whether I have
Put a
the
question
signature-
whether
Yes,
regarding signatures.
Yes, my lord. Page 521, running page 299, inner page 5 in the middle. My lord, the report consists from page number 1 to 25, and from page number 1 to 25, there is no any signature of the examiner or other officers.
Right.
So, and the head note itself, say, my lord, it's a preliminary report, my lord.
Right. Yes.
My lord, so your lordship made a query, my lord, how the trial court dealt with it. Your lordship will find it at page 1977, para 153, my lord. Only by that saying that Anwar's husband, that 65B, my lord,
153.
is not required. 1977.
Para, please. Paragraph.
Paragraph 153, it starts, my lord. PW 19, BW, I'll not read that, my lord, will come directly. Because the trial court was of the view since the hard disk was produced, so it is all fine. There is no question of any transferring as such. And secondly, my lord, so the 65B certificate is not required, taken care of that, my lord. Last line, does it transpire?
There are 153, which subpara?
Yes, my lord, I'm giving.
It's
My lord. 53 subpara 12, I believe. No, sir, it was submission. 12, my lord.
Yes.
That it was in an open condition. That is the PP submission, my lord. Now, for
When it comes
14, my lord.
submitted,
Yes.
they did not
1981, my lord.
produce.
Here we deem it opposite to look into the aforesaid case Anwar PV versus Bashir, wherein it was held as under such and such. My lord, that being the position, the submission of the learned special PP cannot be said to be inconsistent with the law laid down in Anwar versus PK Bashir. Accordingly, the submission is concurred with. That is the only finding. my lord. How it is applicable, my lord,
What is
not
the
known.
conclusion? Don't know. All right. Okay.
Then, my lord, I'll finish the evidence, my lord, two evidence more, my lord. Then PW 131 is one Southern Camproy, my lord. It's volume 3, page 647, my lord. Gaon Buda, my lord. Yeah.
PW?
PW 131, who was the Gaon Buda, my lord. Page 646, my lord.
Yes.
Yes.
Six, 4, 6. Yes, please.
My lord, few lines, my lord. Page 646. Today I appeared before the court on reserve summon. I was the Gambura of village Dongdang from 2001 to 9. There were 35 houses in the village where about 130 people used to live. In the year 2007, there was an Anganwadi center in the village. In the year 2007, there was clean water drinking facility in the Anganwadi center of the village. I was interrogated by the police. The witness declared hostile at the prayer of the prosecution. It is not a fact he started, so he has denied. It is not a fact that I have concealed the truth being influenced by Arish Khan. It is not a fact that I have not deposed truly in the court. Now the cross, I do not know who is Arish Khan. The police officer who interrogated me only asked me my name, father's name, and name of my village. The clean drinking water project was set up in the Anganwadi center of the village in the year 2007-8 and said the clean drinking project is still running, my lord. Then, my lord, PW 148 IO, my lord.
page 716, who was not also entitled to investigate, my lord. That aspect, your lordship, we have already submitted, my lord, that he was not the competent power or the power empowered under the NIA Act to investigate the matter. So far, because there were two IOs, my lord. One was dealing with PHE department, and this Santosh Kumar, he was dealing with the social welfare department.
Right.
The CIO never went to that Haplong, my lord. He very much sat tight in Guwahati, my lord. And all things said and done was done by Santosh Kumar, my lord. And that is at page 706, internal page 20, my lord. I'm reading that from below fifth line, my lord. During my course of investigation, I have not visited the office of the CDPO New Sangbar NC Hill. So it is this where, my lord, the documents were there, my lord. He only sat in the circuit house and said that PW 25, the recovery was made from her, my lord, the CPU and all these things. Whereas the witness said that I went to the circuit house and he asked me and I have signed it, my lord.
Right.
Then, of course, I'd like to rely upon the main IO, my lord, because IO that has got many dimension in his evidence, my lord, right from starting of the sanction, the mandatory requirement under 45, my lord. That part has been dealt with, my lord, with the other witness also, ministry person coming and taking the witness box also. So now I'd like to go to the IO's page, my lord. Paper book page 810 and my running page, I have your lordship. এখন দিছিলো পেপাৰ ইয়াতে কোনকে লগাই দিলে নাজানো 313 আৰু IO টো বেলেগে দিছো
Mukesh.
Yeah, I got it. 796, my lord. How about
It's there in that one. इसमें है ये. Yes.
I have not 796 second para, my lord. Second para, I have not personally visited Haflong for the purpose of the investigation of the present case, my lord. So whatever was done by a competent person, that is PW 148 itself has done it, my lord. Next one to go. No, year tinta ase to. Liaison, I have already said. And one thing that utilization certificates, my lord, that the works were done and utilization was also done. He has spoken on that, my lord.
Internal page. What is the internal page?
Yeah, my lord, I'm trying to find it out, my lord. Actually, there is a mix up, my lord. But it's a long one, my lord.
That's right.
Yes, my lord. That liaison officer I've already dealt with the legal aspect of there, my lord. Then one thing, page 819, my lord.
Internal page of.
Internal page 62, my lord.
62.
I have seen exhibit 83 at page 57. I told your lordship, my lord, at the outset, 62 and 83 are the files from by which the money was generated according to the NIA, my lord. I have seen exhibit 83 at page 57 is the utilization certificate. And in this certification, the receipt amount has been shown fully utilized and the said certificate was shown to be signed by the principal secretary and CHS. So the utilization certificate is also there, certifying that all the money that was given for the works were utilized finally, my lord. So there cannot be any siphoning of, my lord.
The principal secretary was also examined? No.
No. Neither is an accused also, my lord. If he was also at wrong, my lord.
All right.
Evidence to evidence, evidence to page 1 now, the Indiate আছে, more ইয়াতে আছে, page 810. My lord, regarding that misappropriate part, my lord, I'll just show it, page 810, internal 54. It is true that from the last paragraph of the final report of the investigation, present case filed under 173 CRPC, I have requested the central government for investigation of the allegation of misappropriation of government fund, criminal misconduct, forgery by the CBI after opening necessary consent from the state of Assam or investigation by ACB Police Assam. I am aware that CBI has investigated the case of misappropriation of government fund, criminal misconduct, forgery, etc. in various departments on it is true that there is no law by which two investigating agencies could investigate the same offense against the same accused persons twice. So, my lord, respectful submission will be this for the future course to come, my lord, because we are also for the society, my lord. In a NIA, there is a special provision, if I remember, section 14, my lord, that any other incidental or ancillary offense can also be tried. It is not that you have to try only the terrorist activities. So these things could have been very well clubbed in, my lord, so that in future it doesn't happen. NIA 14, yeah, my lord. Yes, my lord. My lord, 8, my lord, just for
Yes,
because
yes.
things will come for the power to investigate connected offense. NIA Act, my lord.
Yes.
When investigation any schedule offense, the agency may also investigate any other offense which the accused is alleged to have been committed if the offense is connected with the schedule offense.
You're reading section 14.
8, my lord, first, my lord.
8, right.
Then this power, whether the court has got or not, it will be on 14, my lord. 8 says regarding investigation part. If anything is connected, the NIA may also investigate that part, my lord. Interrelated, my lord.
These are all may, it's not
Yes,
shall.
no, I'm pointing it out, my lord. Then, my lord, they could have done it, that's what I say. Powers of special court with respect to other offense, 14. When trying any offense, a special court may also try any other offense with which the accused may under the code be charged. At the same trial, if the offense is connected with such other offense. In the course of any trial under this act of any offense, it is found that the accused person has committed any other offense under the act or under any other law, the special court may convict such person of such other offense and pass any sentence or award punishment authorized by this act, or the case may be under any such law. So white power has been given, my lord. So that power
Where's
is
the
not
power of investigation, please, once more?
8, my lord.
8. No. The officer authorized to.
Oh, yes, my lord.
It's number section 6
of UAP, my lord.
UAP or?
Yes, my lord.
Section
43, my lord. 45 is sanctioned, my lord.
was this point argued? Was this point argued?
Yes, my lord, and it has brought in on record also, my lord. Iman. 43C, yeah. 45 is investigation. Application for the provision of the code.
No police officer.
43 is the headline say, my lord. Officer competent to investigate the offense under chapter 4 and 6. And in our case, 17 and 18 comes under chapter 4, my lord. Notwithstanding anything contained in the code, no police officer in the case of the DSP constituted under subsection 1 of section 2 of the DSP.
Can come to see directly.
Yes, my lord. In any case not relatable to clause A or clause B or clause BA below the rank of deputy superintendent of police or a police officer or the equivalent rank shall investigate any offense punishable under chapter 4. So the other two IOs, my lord, one IO was of course DSP who investigated the PHE department part. In my case, the other was a mere PSLE sub-inspector. Inspector.
Inspector.
Santosh Kumar, my lord. For
Yes.
that, my lord, I have cross-examined.
No, we are asking whether this argument was raised.
Argument was there, my lord. But whether it was dealt with it, I'll have to find out the page, but evidence is there, my lord. Cross
Yeah.
at length was taken
Yes.
place, my lord.
That the rank itself is there of the officer.
Because one thing is also there, my lord. This is all India NIHA first case, my lord.
We know, we know.
That's why, my lord, at that time, nothing was settled so smoothly, man. Because at that time, there is a question also coming in the cross that NIA was not having a police station also. Because in order to register a case, as your lordship knows, under section 2 of the division, the police station is a must. OC of that station will register a case. Thereafter, only investigation will take place. It is dealt with at page 1894.
Para.
Para 9, my lord, at the initial, my lord. 9, Roman 3, then small a, my lord. Submission, my lord. It is further submitted that beside the chief investigation officers removing the case was investigated by some other officers of the rank of sub-inspector and inspector, and the same is not contemplated by section 43 of the UAP Act, which contemplated investigation of the case under UAP Act by officer not below the rank of DYSP. An investigation by such unauthorized person can prejudice the accused person. The rival summation is that no breach of statutory provision is committed and no prejudice is caused to the accused. It relied upon the decision of the Honorable Calcutta High Court in Kanju Ravi Singh versus Union of India, responding 2004 criminal journal to such. So by relying on that judgment, it was taken care by the municipality.
Yes.
And my lord, the important aspect regarding this part of the evidence.
Okay, then we'll continue tomorrow.
Much obliged. You want Dukan Saman?